lucky to even be here. I thought I was going to blow away.
I want to recognize his award. I can't remember what it was.
Yes, do you want to mention that?
No.
Okay. Yes, he did, yeah. So, welcome to the March 7th meeting, 2017, of the Salina City Planning Commission. And on your agenda as printed, you may note that there is a request for executive session, and I would look to the commission for a motion to that effect.
Mr. Chairman,
Yes.
I move that we recess into executive session for 20 minutes for the purpose of consultation with city attorney on matters deemed privileged by the attorney-client relationship, and to resume an open session at 4:21.
Is there a second? Second. It's been moved and seconded. All in favor say aye.
Aye.
Opposed, same sign. Motion carries. We will be in executive session until 4:21. All right, we'll call the meeting back to order and begin with the remainder of the agenda. First item number 2 on the consent agenda. Second item is approval of summary minutes for February 21st meeting. Do I hear a motion for approval or any corrections, changes?
I move we accept the summary minutes of the February 21st meeting.
Second.
It's been moved and seconded. Is there any discussion? All in favor say aye.
Aye.
Opposed, same sign. Motion carries. Minutes are approved. We begin then with number 3, public hearing items. The first of the public hearing items is public hearing on applications Z1510 and P153 filed by Magnolia Hills Incorporated for respectively a change in zoning classification from A1 agricultural to R1 single-family residential, and secondly, a preliminary plat approval for this 48-acre tract of land north of Magnolia Road and First Covenant Church between Markley and Holmes Roads. Mr. Andrew.
Thank you, Mr. Chairman. This is a public hearing item, which means we provided notice to surrounding property owners with an opportunity to be heard on the question of whether a property comprising 48.8 acres that is located directly east of Magnolia Hills Estates Edition, north of the First Covenant Church campus, and on the west side of Holmes Road is suitable for R1 single-family residential development. The property that we are discussing is vacant land that is inside the city limits. It's currently zoned A1 agricultural. And then the zoning request area, as I noted, is bounded on the west by the existing Magnolia Hills Estates subdivision. There is pasture land on the north, Holmes Road, and cultivated land to the east, the First Covenant Church, and pasture land on the south. And this property does not include a 16-acre finger of land that is owned by Magnolia Hills Incorporated, but is this 16 acres right in that location. So this is the First Covenant Church, this is the existing Magnolia Hills Estates subdivision, and this is the subject property that is not including this extension right there.
Excuse me, Mr. Andrews. We're having just a short side conversation here regarding a potential conflict of interest, and I think that Mr. Linkwitz would like to ask a question before we move on.
Okay.
Mr. Byquist is a client of mine. I manage some rental property for him, so I didn't know if it'd be appropriate for me to recuse myself, or if it's not enough conflict of interest, I can remain.
So Mr. Griggs.
we're just conferring on the issue really quickly.
Regardless.
Close the session is going to be about this. I think this is going to be contentious.
Whether anybody can say it's a conflict of interest or not.
Yeah, but I didn't see staff recommendations here. Did you?
I don't know, but no, I didn't read it all the way to the end, is the problem.
We appreciate the public's patience while we sort this out. We want to be sure that everything is done properly and in the public good.
Okay, thank you for allowing us to discuss that. We discussed the fact that the applicable conflict of interest test is set forth in the Planning Commission's bylaws, and it is whether there's a recognizable financial interest that could likely affect the outcome or would likely put you in a position where you have an interest that is not shared with the public at large. So that is a question that, to be prudent, it would be appropriate to recuse yourself if you believe that you satisfy that test. I'll turn it back to you I figure since you raised the question, you may believe that you do have a sufficient conflict of interest.
One of the things I should probably brought up earlier was the property in question is not related to any of these properties, or it's not anywhere in close proximity to it. I personally don't think there's a conflict of interest, but again, if there's an issue, I'll be happy to recuse myself.
Okay. Would it be appropriate to take a approximately 5-minute break so that I could
Do I hear a motion for executive session to discuss the legal implications of this matter from the commission
I don't
for
think
a
it needs to be
period
an
of 5 minutes?
executive session. It could be
no,
it can just be a short recess.
a quick recess, 5 minutes, to allow me to discuss this.
Because I don't chair it all the time, isn't by definition a recess and an executive session?
No.
No, okay. Is there a motion for a recess?
So moved.
Second.
Been moved and seconded. All in favor, say aye.
Thank you.
Opposed, same sign. Motion carries. We'll recess for 5 minutes.
Okay, thank you for allowing me that opportunity to do some quick research. I wanted to look at the applicable conflict of interest law, and I may have misspoken earlier. I confirmed the statutory conflict of interest test, I believe, would apply to the extent that Mr. Linkowitz has received compensation from the applicant in the prior 12 months. However, the statutory conflict of interest can be resolved by disclosure. So to the extent that Mr. Linkowitz discloses that, which he has, there is no statutory conflict of interest issue. And we're back to the issue of whether Mr. Linkowitz has a conflict of interest that would put him in a position that is not shared with the public at large that might influence his opinion on the matter. if Mr. Linkowitz believes that he can act objectively, and to the extent that he does not have a financial interest in this particular item before you, then he may stay on the board, and it is not required from a legal perspective that he recuse himself. So I would put it back to Mr. Linkowitz to simply confirm that he does not have financial interest in this particular matter, and if he believes he can proceed, that is fine from my perspective.
I would say absolutely I don't have any financial interest in that area, and I think I can be objective.
All right, thank you, Mr. Linquist.
Thank you.
Appreciate you raising that issue, and we will then continue. So, Mr. Andrew, I think it's back to you.
So the property that we're talking about here would be, the proposed development would be centered around two public streets on the west. There's Ridge Hill Drive and Stone Post Lane that would extend east along into this property. And the original drawing that we had a total of 106 lots, but that has been revised downward now to 104. So just to clarify that, we indicated 106 in the staff report. There's actually 104 actual building lots. And so at one time, this entire quarter section was owned by Frank Norton, and the First Covenant Church purchased 34 acres in 2000. In 2005, the current applicant in this case purchased 40 acres for Phase 1, and in 2007, they purchased the remaining 64 acres over to Holmes Road. And this property has been annexed. The original property was annexed in 2000, and this piece that we're discussing here has been within the city limits since 2005. The request is for R1 single-family zoning. That is consistent with the zoning of the existing Magnolia Hills Estates. We provided a summary there of the minimum lot sizes, setbacks, lot coverage, those things, to what the expected development pattern would be, which is essentially a logical extension of the development on the existing 40-acre subdivision. The applicants believe that this property is well suited for development of single-family homes due to its location, topography, and accessibility from Markley Road. They see the A1 zoning as inhibiting future development of the property. Unlike some parts of Salina, this property has a great deal of slope and elevation change. Up in the northeast corner, adjacent to Holmes Road, the elevation's at 1268. In the southwest corner, it is 1298, and there's a number of rises and dips between those high and low points. The lots proposed in blocks 8 and 9 will be elevated compared to the surrounding terrain, which is generally sloping towards the northeast. There are two distinct drainage basins on this property, and the general drainage pattern for the portion the applicant is now proposing to rezone is northeast across Holmes Road and then east over to East Dry Creek. The change in elevation will create positive drainage, but the slope will also create some fairly high runoff velocities. The applicant is proposing to use curb and gutter and underground pipes as part of the stormwater collection system that would send runoff to a proposed detention basin in the northeast corner. One of the most important aspects of this is that this particular property has gravity access to the gravity portion of the existing interceptor sewer line that runs along the south boundary of the property. And so there are no real limiting factors that would prevent or inhibit development of this tract. Because of its characteristics, its proximity to Magnolia Road and Markley, and its proximity to the interceptor sewer line and the Markley Road water tower, the applicant believes this site is suitable for some form of residential zoning and development. As far as the character of the neighborhood and surrounding neighborhood, this property would not abut any other existing residential development except for Magnolia Hills Estates addition to the west. The abutting property to the north is now owned by Wheatland Development Company, which is Dan Daly. That property was purchased from the Oliver Haig Trust. That property is currently zoned agricultural and it's undeveloped pasture land. Holmes Road is our eastern boundary. The First Covenant Church lies on the north side of Magnolia Road directly to the south. And the nearest development that's urban in nature is Valley View Estates, which is up to the northwest on the west side of Markley Road. There is a large amount of A1 and ag zoning in proximity, but we believe that construction of single-family homes would be compatible with the zoning and uses of nearby property, would be consistent with the zoning that the Planning Commission approved for Phase 1. It should not adversely affect neighboring property or be detrimental to the living conditions, value, or development of adjacent properties. The lot sizes proposed are fairly large. The density at 2.2 units per acre is fairly low. And there's a large institutional use to the south. So this type of residential development would be consistent with the anticipated development of the Haig Trust property to the north. And it could be, again, viewed as just a logical extension of the development pattern in this area. It is shown as suburban residential in the comprehensive plan. As far as availability of water, this area is fed by a 16-inch line that runs along the east side of Markley Road. And the utilities director has found that the existing water distribution system would provide more than adequate volume and pressure to serve this development. The First Covenant Church is served by an 8-inch water line that extends off a line on Magnolia. There's a 6-inch line that ties back to Markley Road. And to serve this development, the engineer for the applicant, Cobb Valley Engineering, is proposing to extend an 8-inch line located in Phase 1 and tie it into the 8-inch line serving the church property. This would create a loop system with 2 sources of flow. The details of the actual water distribution network and the layout would be addressed in the plat review process. There is a 27-inch interceptor sewer line that runs right in this alignment here, and as we noted, that is a gravity portion there, and there are manholes along that line, and this development would propose to run internal sewer lines that would tie into those manholes. As far as stormwater drainage, they are required to accommodate the difference between pre-development and post-development runoff conditions. They have submitted a drainage study, and the actual details of that would be addressed in the review of the plat. Fire protection would be from Station 4. There's a less than 5-minute response to the entrance of Magnolia Hills Estates. Police protection would be provided once public streets are constructed and open to traffic. As far as service by schools, this is in the enrollment area for Meadowlark School, Lakewood Middle School, and Central High School. The school district has not reported that additional development in this area will create any crowding problems at the above noted schools. As far as parks, this is in Neighborhood Park Service Area number 7. There are no identified neighborhood parks on the neighborhood park plan for this area. So in lieu of dedicating land, the developers would be responsible for paying a fee in lieu of dedication. That's $200 per dwelling. As we've much discussed, neither Markney Road or Magnolia Road are built to city street standards, but they are paved. They're in good condition. They're certainly capable of carrying the traffic volumes that they carry. Holmes Road in its current condition is not. Magnolia Road carries 4,800 vehicles a day west of Markley and 2,200 east of Markley. Markley carries 4,200 cars a day north of Magnolia. Holmes Road, the current traffic count is 185 vehicles a day. Certainly if this has a full build out and there's a physical connection to Holmes Road, which is what is proposed and planned, then that's going to introduce additional traffic. At full build out, we or recognize that this will probably generate about 1,060 vehicle trips out of this subdivision, which will be dispersed both east and west. The important thing is how this subdivision relates to the street network around it, especially Holmes Road, and so the phasing of this development and the timing of the future connection to Holmes Road becomes an important factor in the dispersal of traffic. As we talk about the comprehensive plan, this does show as a future suburban residential area, and the comprehensive plan states that future residential growth is envisioned to the east and southeast of the current city limits. The existing residential development pattern and services, as well as the proximity to infrastructure and developable land, make this an ideal place for future neighborhoods of Salina. So we have summarized for you that suburban residential is primarily single-family residential at a density of 2 to 5 units per acre, and the character of this proposed subdivision is consistent with that designation. I think, John, I have just an excerpt from the comprehensive plan on growth and development. Do you think you could put that up? And it would be the growth and development one, John. So this is in your packet, but it indicates that to promote responsible growth, areas have been identified to accommodate different types of development, including residential, commercial, mixed use, and employment. In general, the growth areas recognize existing uses, investments, and land available for development. New growth should occur in a contiguous manner adjacent to existing development supported by public infrastructure. And so as staff looks at this property, it is proposed to develop in a contiguous manner with Magnolia Hills Estates Edition, and it is an area that the development is supported by public infrastructure already due to the water and sewer lines in the area. So on page 7, we have summarized some possible findings, and these findings would be that the property is not suitable for development of single-family housing under the existing ag zoning. The location and physical attributes of the property, the available public utilities, make it suitable for urban density residential development. This would be a logical extension of an existing residential subdivision, and the R1 zoning would be compatible with the zoning and land use of nearby properties. Needed public utilities can be readily extended to serve this site, and the requested zoning change is consistent with the comprehensive plan, which calls for suburban residential development in this area. The primary thing that has changed since our previous discussions is that the city subdivision regulations now make it a requirement that direct access perimeter streets, in this case homes, be paved to city street standards. And since this has been adopted and codified as an improvement standard, we think that allows a finding to be made that this property cannot be developed without improvements being made to Holmes Road. So with that, we would recognize that on page 8 we've given you 4 alternatives. One be to recommend approval of the R1 zoning subject to satisfactory plating. You could recommend a less intense change to R zoning based on the lot size being proposed, which would not be consistent with the R1 zoning next to it. You could recommend that this application be postponed to allow the applicant or staff to provide additional information, or if on the next item you think substantial revisions need to be made to the plat, or you recommend denial provided appropriate findings are made. We would recommend that in considering the rezoning application, that if there are major issues in your mind associated with the plat, that the items should be joined together and considered concurrently. But at this time, we would take any questions you have about the rezoning aspect of this, and then we'll get into the plat itself.
So
The question
Commissioners-
here is whether this property is suitable in its present state for single-family residential development.
So Commissioners, are there questions for staff?
Mr. Chair, if I may
Yes.
really quickly revisit the issue of that was raised by Mr. Linkowitz. I was just reminded, I spoke to the issue of the statutory conflict of interest test and how that can be remedied by simple disclosure. That is true. However, the disclosure can only occur by filing a statement of substantial interest with the county clerk. So there's two things I wanted to mention. Number one, you only have a statutory substantial interest if you have received $2,000 from the Mr. Byquist or the applicant in the preceding 12 months. If you have received at least that amount, I think you could satisfy the test if you simply acknowledge that following the meeting, you will file a statement of substantial interest indicating that interest with the county clerk's office. If you do that, I think you can continue to be part of this discussion. If you're not willing to make that disclosure, because that's the only way it can be made, then you would need to recuse yourself.
I can go ahead and file that. I don't really see any, again, due to the proximity of the property being so far removed from the property I managed for Mr. Byquist, they're just not related. But to answer your question, I have received over the sum of $2,000 in the last 12 months for management fees.
And so it would just be a matter of filing a statement indicating that with the county clerk's office. And I misspoke earlier because I indicated that you could make that disclosure verbally, but that does need to be done in writing. So if you agree to do that, then we can proceed.
Would it just be beneficial in terms of time for me to just recuse myself? That way there's not any appearance of conflict of interest, or the waters seem to be rather muddy right now.
I didn't mean to complicate it. I wanted to clarify that one issue. I think, we spoke about what, if you believe that it's not a conflict that you can overcome, then it is prudent to recuse yourself. But I do think it can be remedied by that simple act, which wouldn't take very much.
This is not intended to be a flip comment, but I think that the attorneys always are there for the purpose of making sure that all the legal boundaries are met. And so it still would be up to you, Mr. Linquist.
I'll go ahead and recuse myself just to kind of, I think, make things a little clearer, and hopefully you didn't misconstrue any comment I made. I mean, I respect the information that you brought forth, and hopefully you didn't take that comment in the wrong way.
Oh, no, absolutely not. I just wanted to make sure you understand what would have to happen for you to satisfy that statutory requirement.
And I'll just recuse myself.
All right. I appreciate everyone's concern with making sure that this is done properly and in good form. Thank you, Mr. Linkwitz and Mr. Martin.
I have a question.
Yes, other questions for staff?
I would simply recommend that during the period of recusal, Mr. Linkowitz
Certainly.
sit in the audience. Thank you.
Right.
Mr. Andrew. I'm having some concerns with, it feels like we're trying to do A and B at the same time, but yet we're really doing A first. Is that correct?
The first question is whether the property in question is whether the residential single-family zoning is a suitable zoning classification and land use for this property.
Right. Okay.
What we're simply advising you is that if there are concerns about the plat in terms of its current layout or something that would require major redesign or revisions, then the the recommendation to zone the property to R1 should not move forward if there's not an agreement that the associated plat can be approved also. Because one without the other is not a benefit to the applicant. They should remain joined together from a timing and review standpoint.
Okay, and I don't understand why having a piece of property not zoned R1 and being vacant is a detriment to anyone as opposed to being agriculture and remaining vacant. I don't see why that's important.
One of the questions or factors is, are there substantial reason why the property has remained vacant as zoned or cannot be used in accordance with the existing zoning? And so the substantial reason why the subject property has remained vacant is that it must remain vacant under its agricultural classification. In other words, they can't build homes on this property or use it for any development purpose under the current agricultural zoning. So one of the reasons that it is vacant is because of its current zoning.
Right. I understand that it's agriculture and why it's vacant now. I guess what I'm curious about is if it were, the zoning were changed to residential, it could in fact remain vacant. But it would remain vacant through the choice of the applicant as opposed to by zoning.
Right, but what you need to look at is what development rights are conferred by the residential zoning compared to what development rights are conferred by the current agricultural zoning. And the current agricultural zoning does not give the owner the opportunity to develop the property for residential purposes. So it is inhibiting their ability to develop the property. And that is one of the tests, is whether the current zoning, if you in your minds can come up with an alternative development that could be made use of on this property under its current agricultural zoning, that's a fair consideration, but there is really no option for developing this property in any meaningful way under the current zoning.
Are there other questions for the staff?
Yes. And then, if I'm understanding this right, even if we did zone it to R1, in its current state, it's not proper for development because of the home survey issue.
Yeah. Can we pause for just a minute? Are we on mic?
Oh, sorry, this one wasn't on. Sorry.
Okay. Would you like to repeat that?
Not really, but I will. And then I want to understand that if we did vote to change the zoning to R1, in its current state, it is still not adequate for development because of the Holmes Road issue.
The recommendation is to recommend, or one of the options, to recommend approval of the applicant's request for R1 zoning subject to satisfactory platting of the property. If they never get to the point where they can submit a satisfactory final plat of the property that addresses all issues, then the R1 zoning will not take effect. And so, obviously, in its present agricultural state, you cannot develop it for housing. There's going to have to be an investment in infrastructure made by the applicants in order to make this developable property. But absent a zoning change, every subdivision that we have in the city of Salina is zoned either R or R1, denoting its intended land use. And so John, if you can go back to the zoning map on this. So what you see is that all the area there is green, is currently zoned agricultural. The First Covenant Church is zoned residential suburban, but this area here is zoned R1, and they're requesting to extend that yellow pattern over into this area to have essentially a second phase of Magnolia Hills Estates. And then, John, I think somewhere within there is, I think under 6 is the concept sketch. And just for the benefit, you may need to blow that up a little bit. But back in 2005, when Magnolia Hills Estates, what I call number 1, was proposed, the Planning Commission reviewed this, which was the plan for the ultimate build-out of this quarter section. And so it was always contemplated in 2005, when this was initially brought before the Planning Commission, that this would be phase 1 of a multi-phase residential development, and we are now at a point where they're requesting to move forward with the second phase. The first phase was 40 acres, the second phase being 48 acres.
And I hope this is maybe clarification for public as well. The second item, as we mentioned, is about the preliminary plat, the one we'll take up right after this. And there are specific suggestions as to what is and is not complete for that plat. So there's a whole discussion yet to come about that plat. But as Mr. Andrew properly points out, we have a couple of options. One would be, as he said, the number 1, to recommend approval of the applicant's request subject to satisfactory platting. There's another, number 3, that it be postponed until all of those criteria are met. So I think it's important to highlight that.
Right. The number 3 is there is if you, in your minds, believe that staff or the applicant has not provided you sufficient information about this rezoning request, if we fail to tell you about fire protection, or we fail to tell you about sewer service or water or those types of things, we don't believe that we have failed to inform you about any of those factors relating to this property, but that option is there nonetheless if you think that we have failed to inform you about something.
Are there further questions?
Yes, I have a question about drainage, and there's 3 references to drainage, saying that the First Covenant Church has a stormwater retention pond. The present Magnolia Hills has a stormwater detention pond, but the ground does slope to the east, and there is an intermittent creek that runs from the Covenant Church stormwater drainage through the property through to a proposed stormwater detention pond and crossing Holmes Road into a wheat field. Now, in the information provided, there's going to be high velocity water flow, and if that stormwater detention pond can only hold, say, 1 inch of rain or 2 inches of rain or 3 inches of rain, and we get an excess amount of that, that water is going to run directly into that wheat field. And that would cause erosion and siltation of the dry creek and other problems. And has that issue been addressed?
That issue is a requirement that will be addressed as part of the satisfactory platting of the property. It is addressed on a preliminary basis now, but we have criteria for stormwater detention ponds, and they have to be able to detain a 25-year storm event. And the plan is, instead of having the intermittent stream, the plan is to have a stormwater collection pipe Again, you have to realize that when there's a detention pond, such as the First Covenant Church pond or the pond here, the water is released from that pond at a controlled rate and not at a high velocity rate. But there is a plan to construct an underground stormwater pipeline that will take the discharge from the First Covenant Church pond and take it underground and carry it to the stormwater detention pond in the northeast corner.
Okay, and then from that northeast corner detention pond, there'll be a reduced flow. Right now, there's a box culvert under
There's a
Home
box culvert under Holmes Road.
So, but there would be some restricted flow then.
It would be restricted and released at a controlled rate. And we'll address that in more detail on item 3.1B.
Okay.
Mr. Andrew, I'm hoping I understand this technically correctly, but proper platting of the property is one of the factors that Planning Commission would typically would see is desirable. It needs to be platted properly before approval. Does that platting process include reaching an agreement with the City Commission as to Holmes Road and a satisfactory agreement being reached?
What would occur is if the action today is to move forward with a favorable recommendation on the zoning and you approve the companion preliminary plat, your recommendation would go to the governing body. At that point, and there would be a resolution of whether a development agreement could be reached or not. If there's not a development agreement reached and the developers are not willing to pay to pave Holmes Road to city street standards, then I imagine the application will die and it will not come back to you in final plat form. If there is a development agreement reached, that will occur before a final plat comes back to you. So the condition addressing satisfactory platting of the property, that platting of the property would occur after the development agreement has been reached or not reached.
So to paraphrase what you're saying, from my understanding, we're looking today at a preliminary plat, and what we would be looking at finally, once an agreement might be reached, would be the final plat, which is yet to come before this
That
commission.
is correct. The
Thank you.
final plat is the final version. It is the portion that is recorded and is what lots are sold off of and infrastructure is built off of. The preliminary is, we're in the design phase. We're not in the ready for infrastructure stage. So we're in the preliminary design stage, and says as part of our plan to develop this property residentially, the preliminary plat informs you of what the intended design is for the subdivision that goes with the zoning request. But they are two separate items, and the question before you on this item and the public hearing item is the most appropriate land use of this property residential development, single family, or continued agricultural use? And to say continued agricultural use, you will have to come up with some findings that why this is not suitable for continued expansion of the residential subdivision.
Okay, before we open it to the public, are there any further questions for staff?
Yes. We've talked, and it's in the comprehensive plan, and I can't find it, and some of the information that you gave was that we strongly encourage connectivity, which this location lacks. It has no sidewalks, bike trails for development. Will that be addressed in the final plat?
It will not be addressed in the final plat. We will address it when it comes up during the preliminary plat. We will discuss Holmes Road in detail. We will discuss the amenities that this will have as it relates to the comprehensive plan. But the question on item 3.1A is whether you think this property is suitable for development with single-family homes, or whether it is more suitable for continued agricultural use.
No, because we need to hear from the public, yeah. Are there any further questions for staff before hearing the public? Hearing none, the microphone is open. If any members of the public would like to comment on this issue, now is the time to do that. Seeing none, I'll bring it back to the commission for any further discussion or motion.
I did want to report that these are people who, some of whom could not be here today, but we did send notice out to adjoining property owners. And the number one issue, there were several owners who were opposed to the property being developed at all. And then there were some who were not opposed to the property being developed, but expressed a concern about large construction equipment or traffic coming through their main entrance off of Markley Road to get into this area for construction purposes, for streets, water, sewer, that type of thing. And their question was posed to us: can the city or can the Planning Commission require or at least encourage that that there be a construction road constructed off of Holmes Road? So in other words, if this is approved and they begin putting in streets and utility lines and things in here with heavy equipment, can we require that equipment, that there be a construction road and that enter into that site? I think that can be addressed through the platting and the phasing of the platting, but we did want to differentiate between the first question deals with things like graders, earth movers, dump trucks, things like that. I think the position of city staff is that we would prefer that type of heavy equipment go in and out via Holmes Road and not travel on the existing residential streets. The second question being is, once streets and utilities are in and people start building new homes, there's nothing we can do at that point. We cannot tell contractors that they can't drive in and out of the area to their construction site on the existing city streets. But we do think we can have some measure of control on how heavy equipment installing streets and water and sewer enter and leave the site, so that it's not, one, an intrusion into the existing neighborhood, and secondly, that they're not tearing up the existing paved streets with that type of heavy equipment. The other thing I wanted to point out is that presently, and you might have to zoom in a little more, John, the Planning Commission in 2005 required, because these were going to be extended and we didn't know when, and we didn't put cul-de-sacs on them in lieu of cul-de-sacs, there are little gravel roads here that tie Ridge Hill and Stone Post and Cason and Dunwood here, and the purpose of those was to provide a place for fire trucks, trash trucks to circulate and not have to go down a dead end and be forced to back up. Some of the neighboring property owners are not fans of how these have been maintained over time, but again, that was required by the Planning Commission with the best of intentions to provide good emergency access and also for trash service there, to be able to have the trash trucks and other vehicles be able to circulate and get up and down those streets. So obviously these gravel turnarounds will come out, and the plan is to extend Ridge Hill, Stone Post, and Cason to the east as part of this subdivision.
So the chair is indebted to Commissioner Good for pointing out that I neglected to ask the applicant for any comments, and so let's make time for that. Does the applicant have any comments?
We have someone here from Caw Valley representing the applicants. Do you have anything to add about their plans for developing this and any of the infrastructure plans.
Thank you. All right. Thank you.
Mr. Chairman, are we ready for a motion?
I am.
I move that we recommend approval of application Z15-10, requesting R1 zoning for the subject property, and list the findings 1 through 4 on page 7 of the staff report.
Commissioner Boxer, can you clarify on page 7? Oh, I see. Yeah.
I'll enumerate them. Subject property. Excuse me, I said, they're actually on page 8.
I'm missing a page 7, actually. No, I'm not. Here it is.
The options for
Excuse me,
action,
they
you're
are-
talking about option 1 on page 8, supported by the findings on page
Right.
7.
There you go. And those options state that it's logical extension, they're public utilities, it's consistent with the comprehensive plan, and it's suitable for single-family development. The only piece, yeah.
Okay.
I'll second.
Thank you.
Just for my own clarity, Commissioner Boxer, are you then suggesting taking up option 1, approval subject to satisfactory platting of the property, including those items you've mentioned?
Yes.
That was a yes, Commissioners. Is there any further discussion? I want to just say that I'm a little bit torn about this because staff recommendation is that they would like to have ducks in a row when it is submitted. We have at some length talked about the roads as a part of this. There are clearly some things that need to be done yet according to platting of the property. So I would have to say, a bit torn about what the proper procedure is, although I think it can be said that this allows for those conditions to be met. Yes, Commissioner Boxer?
You can always cast your vote in disagreement to the motion. That's how we move ahead, or not move ahead.
Yeah.
But am I understanding the motion? If it is subject to satisfactory platting of the property, that means that the Holmes Road issue needs to be worked out.
Well,
Yes,
I think
we are
if I
we
may-
are assuring you that
It will be,
and
yes.
we'll discuss that on the next item, but you really don't have any discretion about what happens with Holmes Road. That's going to be decided by the governing body. All I can tell you is if there is not a satisfactory solution, you will never see a final plat for you to worry about.
Yeah, what we're talking about is the preliminary
This is a
platting
preliminary
of the property.
plat, and
Should
you're
the roads will become an issue, and I think we addressed that a minute ago. If the final plat comes back to the commission, that would be the place at which we would approve or disapprove city commission having an agreement on the road
To
issue.
explain why I made the motion and why I'm going to continue to support it, I'm going to make it as simple as I can. It's kind of like chicken and egg.
Yeah.
If this remains agriculture from now until you name the date, there will never be a plat. There will never be Holmes Road. There will never be all those things. And so my contention, right or wrong, and that's what prompted the motion, is that if we get it zoned as residential, then the ball begins to roll. And that's why I'm doing that.
And
Right or wrong.
I agree, because we are talking about the whole 48 acres. We're not talking about the 12 acres of Phase 1. Is that correct?
That's correct.
Okay.
What we're talking about is the area outlined in blue, and that they have requested to rezone 48 acres to R1 residential. And just to put it in perspective, this is 40 acres and 95 lots, and this is 48 acres, and they're proposing 104 lots.
Any further discussion? If not, all in favor of the motion, say aye.
Aye.
Opposed? Opposed, same sign. Motion carries.
So that is in the form of a recommendation that will go to the governing body as to the appropriate zoning of the property.
All right.
And
So,
item 3.1B will then get
Right.
into the meat of the design.
right. So let's go to 3.1B, plating.
Okay, as we reported to you, the reason this has a 15 application number is the original application for this was submitted in 2015. We're now in 2017, having discussed this at some length. And since that time, we have worked with the applicant and their design engineer, Cobb Valley Engineering, to address some technical issues that we had related to the plat submittal. And then also since that time, city staff, the applicant, the planning commission, we have all wrestled with the unresolved issues associated with upgrading Holmes Road to a suitably improved street capable of handling the traffic generated by this proposed development. Because we concluded eventually that we didn't really have a clear set of regulations in place to address this situation, the City Commission imposed a 90-day moratorium on the approval of preliminary plats with frontage on unpaved roads on March 7th, 2016. Then you suspended action on the pending preliminary plat, pending expiration of that moratorium. You came together with an initial draft of a subdivision text change that went to the governing body. They approved it on first reading, but then on second reading it was deferred and the moratorium was extended an additional 60 days to allow further modifications to be made to the draft ordinance. You recommended approval of that at your April 16th meeting, those modifications, and it became final on the 27th of August, and the moratorium has expired. And initially there was some discussion about the order of things, and there was some discussion that a development agreement should be finalized first before you considered a preliminary plat. But in this case, because a plat had already been prepared, it was decided that the governing body should wait to see if the plat layout was approved by the Planning Commission before considering a development agreement, because if a preliminary plat was approved, then there would be a layout and location of street connections and things pinned down at that time as they considered the development agreement. So this request is for the same 48.8 acre tract. You know that it's bordered by the existing subdivision on the west, the church on the south, Holmes Road on the east. As proposed, it would be subdivided into 104 individual residential building lots for single-family home construction. And again, we have this is where the church is, and we have this piece down here that is not part of the layout. The text amendment that was approved in 2016 defined the terms perimeter street and direct access perimeter street, required that subdivisions abut and have frontage on a direct access perimeter street and have at least one public street access point on that direct access perimeter street. It also directs the Planning Commission to look at the need for additional emergency access points. In addition to that one direct point, the subdivision regulations state that a new subdivision shall have any additional means of access in and out of the subdivision, either by direct street connection or indirectly to existing streets and adjoining subdivisions as are determined necessary by the Planning Commission. And so as we look at this, you might need to blow that up some, John, because it's really small. This is Cason Lane, this is Stone Post, and this is Ridge Hill. And so in terms of our connectivity or points of connection, we have 1, 2, 3 on the west, and then this is a proposed street connection here where Stone Post would come all the way through and connect to Holmes Road at this location. So our interpretation is that Holmes Road is the direct access perimeter street for this subdivision, and as such, it is required to have at least one public street connection to Holmes Road, and that the developers are responsible for upgrading Holmes Road to city street standards unless a development agreement with an alternate standard is approved by the governing body. So John, I'm going to ask you to go to, let's see where you, I don't. So we don't have that in slide form, so I will refer you to, there's a section in your staff report that has a divider sheet that says Holmes Road. And the next sheet after that is the perimeter street analysis that staff went through relating to Holmes Road. And so as we looked at this and analyzing this subdivision, the first question is, does the proposed subdivision abut and have frontage on a perimeter street? The answer is yes. This subdivision has 1,152 feet of frontage on Holmes Road. And in our interpretation, that meets the definition of a direct access perimeter street from which a direct means of access is required. So under that text amendment, this is not optional or discretionary. This subdivision must have at least one means of connection to Holmes Road. As far as the classification of Holmes Road, it is a minor arterial street. It's not identified as an impact street, but there's a presumption in the comprehensive plan that all arterial streets will be built to a complete street standard, and that any deviation from that design should be the result of deliberate and formal action by the governing body, the city commission. So that will be addressed at that time. Obviously, the question is, does Holmes Road meet city standards? The answer in its present condition is no. And the city street standard that was required there would be a concrete street with curb and gutter, storm drains, and sidewalk on both sides of the street. Interim streets are only required to have curb and gutter, or not required to have curb and gutter, and sidewalks are required on only one side. And then the other aspect of the subdivision regulations deals with what we refer to as a connecting street segment. And the connecting street segment is the segment that is from the south edge of the subdivision here to Magnolia Road. And so they are also responsible for improving that, which is a 1,247 foot segment of Holmes Road that connects to the nearest improved arterial street, which is Magnolia Road. So not only would they be responsible for upgrading Holmes Road abutting the subdivision, they would also be responsible for having an improved connection to Magnolia Road as part of the development. And then question 5 is, does the applicant or the developer plan, is it in their plans to upgrade Holmes Road to city street standards? What they have indicated to staff is that no, they do not think it is financially feasible for them to bear the entire cost of upgrading 200 or 2,400 lineal feet to city street standards, and that is why we have the development agreement as an option to both address the level of the improvement, the method of financing, the timing, and any public participation or cost sharing. But that is not part of your deliberation today. And so the 6th question is, what discretion do you have regarding the application of those standards? You don't have any discretion at this point, because from your point of view, the only option the developer has is, if they are approved, then they are responsible for improving the abutting Holmes Road and the connecting Holmes Road to city street standards. And as far as you're concerned, that's what their responsibility is, and it's up to the governing body to decide if there's different ways of paying for that, financing that, and what the phasing and timing of that would be. So the negotiating and entering into a development agreement is the responsibility of the governing body, and all you can do today is you approve this, is approve it subject to the condition that the abutting street and the connecting street be improved to city standards. So are there any questions about the analysis that staff went through on that and what your discretion is related to Holmes Road?
Pretty clear to me.
I have one.
I have a question.
Oh, go ahead.
The state of Kansas has indicated that any abutting roads on the edge of the city is to be maintained by the city. And right now, I think it's being appealed whether or not the county should maintain Holmes Road or the city should maintain Holmes Road. And how is that going to affect what the city commission has to say about developing Holmes Road?
Shouldn't impact the standard to which it is improved. The city's position is that if a road is improved to a city street standard, then we will accept it for maintenance. And that has always been the city's position, that once a developer has improved a street and it's been improved to city street standards and determined to meet the city standard, then we will accept it for maintenance. It's the streets that don't meet the city street standard that are in question.
The question, go ahead.
So regardless of who owns the road, either the city or the county, it doesn't matter because they have to meet the city street standards.
That whole subdivision text amendment was based on the premise that it is inadvisable to allow a city urban development to have connection and access to a county maintained road that does not meet city street standards and cannot handle the traffic. So if this is if it is upgraded to city street standards, then it will become a city public street, irrespective of other issues relating to other roads.
Mr. Andrew, I know we're not responsible for hashing out the streets, but I am curious, when we talk about improving Holmes Road, using the diagram that's up there right now, it looks like the street that would empty out on Holmes Road is at the south end of the 1,200 and some feet of abutting property. I'm kind of curious, how far why would we stop after going just 1,200 feet? Why don't we have them do the whole mile? To me, and the reason I bring that up and say it backward that way is that it would seem to me that they could improve Holmes Road to the driveway for the development, period.
But that
And
is...
leave the rest of it dirt.
That has not been the standard or the expectation on any other subdivision. The developer is responsible. Part of the reason we believe that this was placed here was because of that belief, but the fact is that under Kansas improvement laws, the property that is responsible for this section from here to here, this is the benefiting property, and if there were assessments made, this is the property that would be assessed for these improvements, and if you allowed this to occur without that being made, then you don't have anybody to be responsible for that improvement. So the reason that we have broken it down is this is the abutting street, that is the connecting street, that is the lay of the land as they have purchased it and intend to develop it, and the result is that there's 2,400 lineal feet of road that needs to be improved.
And I just find it terrifically, I don't know, that we're going to potentially require 2,400 feet of curb and gutter, sidewalk, street to nowhere. Because as I understand it right now, Magnolia Road doesn't meet that.
Magnolia Road does not meet a
Right.
city street standard
Right.
because it lacks curb and gutter and
Right.
sidewalk.
And that's, like I said, I'm glad we don't have to hash that out, but I couldn't help but say we're going to make a developer do a curb and gutter sidewalk street to nowhere. Neither end of it was going to go anywhere.
Well, it's like the analogy of the sidewalk that goes
Oh, yeah.
nowhere, but you have to start it in some place
I
and
know.
then
I know.
build on it. So this is the first segment of that improvement. So that addresses how the perimeter street question has been analyzed. And as far as design, we don't see any other, in our interpretation, there's no other alternate designs here that could be considered or approved that does not have frontage on Holmes Road, because there is a requirement that the parcel have frontage on a public street in order to be developable, and Holmes Road is that street. There is a requirement to integrate with the existing street network, and as we've noted, there are plans to extend Ridge Hill Drive, Stone Post Lane, and Cason Lane. There's also a plan you see right here for a extension into the property to the north, and then should that property develop, then there would be a physical connection between this and the property to the north, should that develop in the future. The residential streets have a curved linear pattern, and they are designed and laid out to conform with the existing topography, first of all, and also to discourage use by through traffic through the curvilinear design. Curvilinear design tends to slow traffic compared to having a straight shot through between Markley and Holmes Road. So as we noted, this property has 1,150 feet of frontage on Holmes. Then you have the piece to the south. This property is basically rectangular. And again, the controlling design feature on this entire property is the fact that the city has an interceptor sewer line which runs through this property. And John, at this time I may ask you, I don't know if it's slide 5 or the separate PDF, but you have the sewer line. Is it slide 5 on? So just to give you perspective on what we mean by the interceptor sewer line, this is Magnolia Road right here. There's a sewer pump station in that location. The sewer line here is a force main. At this location, it's a force main to here. At this point right here, it becomes a gravity line, and then flows by gravity flow along East Dry Creek and up to the sewage treatment plant. So this line was installed in 1991, and all growth plans for the city have taken into account that this sewer line is there and has capacity to support development in that configuration. So this entire subdivision can be served by the gravity portion of this sewer line, and that is one of the design features. There's a preference from the utilities director not to have that to be in people's yards because it's difficult to get at. So one of the reasons, Mr. Boxa, for that street that comes out in the alignment there is that the street is actually built over the interceptor sewer line, and that is desirable from the standpoint of the utilities director. And so there's only a couple properties that would back up that have their backyard in that, but it's very important as that's a major interceptor that we'd be able to have access to that. And so that is very important from the design standpoint. And so it's Blocks 8 and Block 9 that have lots that go over that, and then Stone Post is built over the east 350 feet of that interceptor line. So as we look at street access and design, obviously we have Markley Road providing access from the east. That's a minor arterial street. The roadway's in good condition. There's no plans to widen or rebuild Markley Road at this time. The applicant has designed a street network that generally conforms with the topography. We have 3 physical connections back to Markley Road. The First Covenant Church has a legal access right across this property to get to Markley Road, and the applicants are attempting to fulfill that. John, if you could go to the cul-de-sac detail number 11. Just wanted to point out that from a design configuration here, this is a street that terminates. Kaysen is up here, but from a design consideration, it worked better to have the cul-de-sac bulb. It's actually proposed on property owned by the First Covenant Church, and there's been a verbal indication that the church is willing to allow for that, provided that the developers pay for the cul-de-sac and allow for a physical connection to that. But I just wanted to be clear that this does take the consent and participation of the First Covenant Church to do that. The alternative, if that's not, is that to bring the bulb back here, and then that's going to change the configuration of those lots.
And Dean, is that eventually going to run into Magnolia? Is that correct?
It's not going to run into Magnolia. It's going to provide it might be an emergency access fire road. It might be a sidewalk. The church could decide that they want to put a driveway there that provides a second means into their parking lot. But John, I guess we'll have to go back to the aerial photo. So the location of that cul-de-sac is about right here. And there would be ability to have a driveway coming out of this parking lot and connect to that, or a sidewalk, just so that there's a connection between the church property and that neighborhood. But it's not going to be a street, and nor would we necessarily want to encourage a lot of cut-through traffic there, but it could be designed in a way that there is a way to facilitate a connection there.
Okay. Well, my real question, though, is why aren't there 2 accesses to Holmes Road instead of just one?
I believe that there is one access to Holmes Road because of the belief on the fact of the developers, the observation that Mr. Boxa made, that by having it as far south as possible, it accomplishes 2 things. It puts a street over the top of the interceptor sewer, which is what is desirable, and by having that there, it was their belief that they would just be responsible to get to there. I think that was part of what is designed. There is no compelling design reason why they could not have a second connection to Holmes Road, but they're only required to have at least one.
One, okay.
And again, this is a preliminary plat, and it could very well be we come back with a final plat that has something slightly different. But at this point, we're saying, have they at least met the minimum requirement for connection to Holmes Road, and they are required to have at least one public street connection to Holmes. So they are proposing a number of streets and street names. One, we've gotten 2 comments on that. One is they have a proposed street name of Fox Ridge Drive, and we did want to point out that there is currently a Fox Burrow Drive, a Fox Tail Drive, and we also have a Fox Run subdivision. The other thing is that the fire department thought it was potentially confusing to have a Ridge Hill Drive and a Ridgewood court, their preference would be if there's a Ridge Hill Drive, that there be a Ridge Hill Court. And so we will work with them on street names. Again, that's a final plat item. All the lots and blocks they have laid out are appropriately numbered. The blocks are separated from each other by streets or other natural areas. There is a drainage detention area set aside in the northeast corner. There's no areas set aside as common open spaces. There's no trails. There's no private parks or open spaces. There is the detention area, and that is it for open space. We have reviewed the lots, and it appears that their width, depth, and area dimensions all meet the requirements of the requested R1 zoning. It doesn't appear, although there's sloping terrain, that there's any lots that are unbuildable by reasons of topography or other barriers. We've discussed the fact that there's a 16-inch water line along Markley. There's a 12-inch line that comes up the hill that serves the First Covenant Church. There's 8-inch and 6-inch lines that loop back, and again, the design that has been submitted provides for a loop system. There's 2 sources of flow into the subdivision, which is what we are trying to accomplish from a fire protection standpoint. The internal water lines will be designed and have to be reviewed by Public Works and KDHE. We haven't got as far to figure out how they are going to be financed. The 27-inch sewer along the south edge of the property will provide the sewer service. There will be internal sewer lines serving the subdivision that will connect to that interceptor line. The property is within Westar service territory, and they have 3-phase electric service serving the church and Magnolia Hills Estates. And they plan to extend that east along the north boundary of the subdivision, then south along Holmes Road to Magnolia. All the electric lines within the proposed subdivision will have to be placed underground. The plan is to extend gas from the Phase 1 area into the development. And as far as the stormwater criteria, they must detain the difference between the existing and developed runoff conditions. And the plan is to detain the stormwater and then release it at a controlled rate into the culvert area and across, eventually reaching over to East Dry Creek as it does today. I don't know if is Mr. Stack still here. He wants to elaborate on the detention criteria, but if you have questions about our criteria, that should best be addressed to him. We've addressed fire protection and fire response, police protection, the school districts, and the fact that they will be collecting a park service fee. And then as it relates to streets and traffic, John, if you could put up the subdivision phasing plan. This is not it exactly. That's not the one that's in the packet, but is that the one you have? Okay. So maybe we can blow that up a little bit, but this is the Phase 1 area. This has actually been reversed. This is not the most recent one. This would be Phase 2 here, but this is Ridge Hill, this street and Stone Post. That would be the Phase 1 of the development. Then it would go to this corner here, and then we would get Phase 3 and Phase 4. And the actual detailed phasing plan would be part, again, of the final plat, but that's going to be an important consideration, and what is going to be an important part of the development agreement and anything else is that at what point is it going to trigger the physical connection to Holmes Road and the improvement of Holmes Road. Staff believes that you could develop phases 1 and 2 with the existing connections back to Markley, but you're going to reach a point where you're going to need to trigger that outlet to Holmes Road and the improvement of Holmes Road, so that the timing of that and the phasing plan. But it will be important that the development agreement address the timing of when the physical connection to Holmes Road is required. And at a minimum, it should be when phase 1 is, or phase 5 is reached here, that we can't have too much of this area all connecting back to Markley Road. Reaches a point where that connection to Holmes Road is going to be required. The dedicated right-of-way, all the streets shown in the plat would be public. There would be dedicated right-of-way for Holmes Road, 50 feet from the center line. We've requested that restricted access be dedicated along the west side of Holmes Road. And we've talked about what the options are for maintenance of the detention area. But on page 8, we've kind of highlighted the responsibilities of the developer. And internally, it's going to be, they're going to be responsible for all the asphalt or concrete paving of 33-foot wide streets with curb and gutter for the internal streets, plus whatever their share turns out to be for upgrading Holmes Road to city standards. 4-foot sidewalks be required along both sides of all internal streets except for the cul-de-sacs. There will be a public sidewalk required on at least one side of improved Holmes Road. They'll be responsible for designing and constructing the detention pond in the northeast corner. They were responsible for the design and construction of all internal water mains and public sewer lines. And they will be responsible, if there is one, for any pond maintenance fee and park impact fees. Those are usually collected at the time a building permit is issued. And so we have discussed phasing, and the applicants have indicated that they hope to use special assessment financing in phase 1. There's no property owners outside the subdivision or in the first phase that should be impacted by those assessments, but that decision will also be made by the City Commission. As far as having restrictive covenants, we have not seen a draft set of those. We usually get those with the final plat. It is our understanding that there is a plan to have covenants and architectural restrictions similar to what there is in the Magnolia Hills Estates addition. And again, this is consistent with the suburban residential designation in the comprehensive plan. The growth and development portion of the plan says new growth should occur in a contiguous manner adjacent to existing development supported by public infrastructure. And so all the public infrastructure is in place except for, obviously, the condition of Holmes Road in its present condition. We've given you the history of what your previous action was. We had a number of homework items for the developer. Those have been addressed. There was one homework item for city staff, and that was exploring the sources of funds for constructing a roadside trail or path along the east side of Markley Road to provide some connectivity to Stone Post Lane to the East Crawford Recreation Area. Neighborhood park funds that have been collected could be used for that, but there's not enough funds in the account to pay for a 2,000-foot path or sidewalk, and so alternate sources of funding would have to be looked at. I can report that the city has completed the construction of a path that connects the Pheasant Ridge subdivision across the north side of Presbyterian Manor over to the existing area as what was discussed at the Planning Commission earlier, and so we will attempt to replicate that, but that's an obligation for the city to try to address that. So, John, if you could go to Trying to find the attachment 5. It's down below 16. And so this is in your packet, but what we attempted to do in our findings in 2016, the subdivision regulations were amended to elaborate on the criteria for reviewing preliminary plats. And so on page 12 and 13, we have staff has made its findings related to those criteria, and we have determined that the submittal requirements have been met for this application. We have a complete application, a drainage study, preliminary infrastructure plan, and a phasing plan. There are no variations being requested from any zoning, subdivision, or access requirements of the fire code. The subdivision is inside the existing city limits and is adjacent to existing development supported by public infrastructure. Adequate infrastructure exists or can be reasonably constructed to serve the subdivision. It is yet to be determined whether Holmes Road can reasonably be constructed, but that is a determination for the City Commission and not at this time. Adequate public services in terms of police, fire protection, and schools exist to serve this proposed subdivision. Police and fire response times are adequate. Fire flows will be adequate, and the schools have the capacity to serve the residents.
You left out parks.
I haven't got there yet.
Okay. You're on 5. You're on number 5.
I am on number 5. But parks is a separate item, and I will be getting to that.
It's number 8.
The subdivision abuts perimeter street that does not meet city standards, but will be upgraded as part of the development of this proposed subdivision. It is consistent with the future suburban residential land use designation in the comprehensive plan. The subdivision layout integrates with the existing and proposed street layout in the surrounding area. It does provide connectivity with property and streets on all 4 sides of the subdivision. This proposed subdivision does not have good connectivity with schools because busing is required, and it does not have good connectivity with parks or support walking or bicycling due to the condition of Markley Road and Holmes Road. One of the questions, in order to have a dedicated physical connection to a neighborhood park, there has to be a neighborhood park, and there are no public parks in the vicinity or proposed within the vicinity for this subdivision to connect to. Holmes Road is an arterial street, and the location and design of the intersection is consistent with the city's access management policies. There's no other curb cuts on Holmes Road being proposed. The right-of-way dedication is adequate. Adequate provision is made for stormwater runoff control through the construction of a detention basin and a requirement for lot grading plans for each development phase. And there is no common area being proposed that would need to be maintained by a homeowners association. So those are our findings as it relates to connectivity and to schools and parks. Our position is that if there is a neighborhood school in close proximity, there needs to be connectivity. Is there a park in proximity? There needs to be connectivity. But if there is no park and there is no school in the vicinity, it's very difficult to have that connectivity. And again, we, as a city staff, are going to try to address the question of having some connectivity from Stone Post Lane up to the East Crawford recreation area, but that is independent of the questions on this. So if you concur with our finding relating to Holmes Road being a direct access perimeter street, and if you believe the review criteria in the subdivision regulations have been met by this application, and the policy and technical issues have been addressed to your satisfaction, and you wish to approve the preliminary plat application, we have recommended 12 conditions on page 14 and 15, most of which would need to be fulfilled either on the final plat or before the final plat comes back. In the alternative, you could, if you find that the criteria have not been met, then a motion should be made to deny the plat, citing what criteria you believe has not been met, understanding that your earlier action was to find that it was suitable for some residential development. And some deficiencies that you might identify can be addressed. Some of them simply can't due to the lack of public facilities such as schools and parks in the immediate vicinity.
Are there questions for staff?
There is the $200 fee for parks amounts to about $20,800.
At full build out.
Could not one of the lots be dedicated as a playground in lieu of that $200 per lot fee?
The problem with that is twofold. One, I'm not sure, we haven't gone through the process of having the Parks and Recreation Advisory Board look at that, but it is the philosophy of the Parks and Recreation Department is to have a limited number of well-located and suitably sized parks as opposed to having a lot of small parks from a maintenance standpoint. And so if there is a park or open space to be imposed, that would have to be a private park or open space. We don't. What we have is that if we have an area where a neighborhood park has been identified in the neighborhood park plan, we try to get that park land set aside as part of the platting. Where we don't have that, we try to get a collection of the park fees so that those funds can be used to enhance park facilities. Obviously, we're not generating enough money to buy land for a park.
And would that money be enough to provide connectivity?
It might be enough to provide connectivity eventually, but it's going to be very slow to come in, and that's one of the drawbacks of having the park fee collected at the building permit stage, is that we had the plat of Magnolia Hills Estates Edition approved in 2005. It's now 2017, and it's approaching build out. If we took that same time frame, then we're looking at the year 2030 or something like that when we would get, so that's going to be a long time to wait. I have discussed this with Mr. Stack, and we are looking at for alternative means, including the CIP and other sources, to get the physical connection from Stone Post Lane up to the East Crawford Recreation Area. We realize that that's an important consideration. And park funds are a partial source for that, but there's not enough funds in there to do the whole piece.
Okay. And couldn't that we make it a requirement of the plat approval that connectivity be provided?
We could not, because you cannot ask this development to remedy an existing condition that already exists. They can only be asked to deal with impacts that they are creating, and they did not create that gap between Stone Post Lane and the East Crawford Recreation Area. That would be an off-site improvement that would be very difficult to tie back to this particular proposal.
Are there other questions for staff?
And I do have one other question. There are schools, and I understand it's maybe out of the purview of the Planning Commission, but there are schools that are closer to this subdivision than Meadowlark, for instance. And what's the school district's reasoning for not busing those students down Magnolia?
The school district they have changed their approach. They went from a strict north-south boundary to now creating feeder schools that feed into the middle schools and high schools. But historically, the enrollment boundary was Republic Avenue over to the river, and the river south, everything east of the river feeds into the Meadowlark, Lakewood, and part of the reason for their reasoning for doing that is they're trying to maintain an enrollment balance between Central High School and Lakewood and South Middle School and South. So they're trying to balance where new residential subdivisions go, and so to keep the enrollment in balance between Lakewood, South Middle, and Central and South High, they have designated this as in those enrollment areas.
Any further questions for staff? Would the applicant like to address the commission? Any specific questions for the applicant? Are there members of the public who would like to comment?
Thank you, Commissioners. Lee Leglighter, 2523 Stone Post. I was joking with my neighbors earlier that staff report can get long, but in all seriousness, I do appreciate the comprehensive nature. I learned a couple of things about my neighborhood tonight as far as where the sewer lines were running and how things are draining, so I do appreciate that in all sincerity. I've lived on Stone Post for the past 3.5 years. Got a great neighborhood. Enjoy the neighbors, enjoy the character of what's been created out there. I don't oppose additional development to the east. It's my understanding that the proposed development that's before you would be done by the same developer that created what's there now. And so I would imagine that we would get more of the same with additional great neighbors, a character of a neighborhood that I'd continue to enjoy. I do want to express some concerns, though, and I think it primarily relates to the site plan, the plat that's in front of you. And some of this has already been raised by Mr. Andrew with respect to the prior application that was before you regarding a construction access. On Stone Post Lane alone, we've got a total of 12 houses there right now. We probably got just as many kids that are kindergarten age or younger that live on the road. And I would imagine that number probably will only increase with the number of young families that do live on Stone Post. And so when we see a thoroughfare essentially going from Markley to Holmes, there is concern there that we reduce or eliminate what construction traffic we could during the development of this plat. Right or wrong, my guess is that the individuals that live in the neighborhood will probably be more conscientious to kids playing in the street or on the sidewalks or in the area than somebody driving a dump truck or a cement mixer or other heavy equipment down that road. And so I think that as part of the approval of your plat, I'd request that there would be some sort of construction access coming from Holmes Road. I think that may also be able to be addressed in the legal requirements for the new plat. And this is something that I'm hoping that, Mr. Andrew, you can help me with as we kind of parse through this. I'll point your attention initially to page 7, paragraph 10 of your staff report. The second paragraph there, your recommendation was to eventually have the trigger for a physical connection to Holmes Road in development of Phase 5. And I think if you flip to that phasing map, that would be towards the end. And so essentially, we'd be developing phases 1 through 4 without a connection to Holmes Road. I wonder if it wouldn't be more appropriate to go ahead and install stone posts all the way through, because we're basically abutting all of the phases 1 through 6, with stone posts. And so to me, if you already made the construction access from Holmes Road all the way through, connecting on stone posts where it currently ends, you probably address that in some respects. And there may even be a legal requirement for that, because as I read the city ordinance 3674A2A, we're talking about a minimum of one means of street access directly from an abutting perimeter street. We've talked about that already. That would be Holmes Road. But I wonder what effect that ordinance has if we don't require the applicant to go ahead and have that thoroughfare, that connection throughout all phases of the project. Because as you said, we could be to 2030 before we even get to phase 5. What purpose would we have to have that requirement if phase 1 doesn't have to use that particular access? And so maybe I'd turn it back over to Mr. Andrew, and maybe he can address that question.
Yeah, and it's not trying to pass the buck or anything from the standpoint of looking at it from the developer's perspective, obviously allowing them to move ahead and sell and develop lots in phase 1 and 2 allows them to sell lots, generate some revenue from those sales that they can then apply to the cost of constructing Holmes Road. That is one aspect of it, and then the other aspect of it is just selfishly from the city's perspective. If there's any cost sharing or burden placed on the city at large, then that allows a reasonable amount of development to occur before the requirement that be built all the way through. The applicants have, in previous cases, addressed during the development of that text amendment and other discussions that if that was an upfront cost to them to do phase 1 at their own expense as part of that initial development phase, that might make the development not feasible. So it has less to do with the need or desirability for that and more to do with the cost and practicality of that. We didn't call much attention to it, but this was placed in here as a traffic calming device, this roundabout in here, that as a idea that roundabout will be a traffic calming device that will slow down that traffic. But there's two aspects to that. We think that this needs to go through and see what the results are of their efforts to negotiate a development agreement, and then where this would be pinned down would be in the final plat that comes in, that we would have a binding phasing plan and we would have triggers within that final plat. Our comment in the staff report is that what we don't want to see happen is to get virtually everything lot in here developed, all 104 lots, and say, okay, now there's going to reach a point where we get into some of these phases here where the fire marshal is going to require at a minimum an emergency fire access in here to have a second way in because of the number of houses here. So it is not off the table that phase 1 could consist of, but in order to have the connection to Holmes Road, then you're going to have to address the improvement to Holmes Road right off the bat, and it remains to be seen whether that is feasible, and that's something that would have to be, we believe, addressed in the development agreement. But certainly we cannot go through this process without having a firm, agreed upon trigger for when the connection to Holmes Road and the improvement to Holmes Road has to be made. But we think it's not premature to discuss it, but it's premature to try to pin that down. But certainly, we would never have a final plat that would go through without a firm trigger and a phasing plan that is binding.
Does the
As
applicant...
somebody that lives on Stone Post, did I say that right?
Yes.
Where do construction, heavy equipment, people, how do they service the areas that are still being built out in this first initial phase? How do they get in and out of the site?
Well, there's a south entrance, and that's currently
Well,
where
that's been in the last 2 or
right,
3
and
years.
that's where all the construction's at right now. So Ridge Hill, Cason, Stone Post, all of those have been filled in for probably 3 or 4 years now.
Mhm.
And so the main access route is through the southern entrance, which
Right.
really wouldn't be an access point for
Right.
development to the east.
And I wasn't wanting to be adversarial about it, but there was one construction address when the first phase of this began, and it wasn't until quite a little bit later that some trigger came about that there was a second access further south on Markley, and I think that's the same kind of thing that Dean is relaying here too, is that, you know, there may not be a trigger on the first 5 lots that are developed or the first 20 lots, but at some point there will be a trigger and there will be another access built, much like was done in the existing development.
We had a phasing plan here, and the initial first 3 phases were essentially done with Stone Post as a public street, and this was an emergency fire access here. And then once they went beyond phase 3, that triggered the requirement to construct the second way in, and that was all set out with the Planning Commission's phasing plan. But we haven't, other than to recognize that there needs to be a trigger for when Holmes Road needs to be a physical connection and an improvement. We think that is an aspect that the development agreement needs to address, because timing, cost sharing, all those things we think will all be part of any development agreement between the developer and the governing body.
Does the applicant have any information they would want to supply at the moment that might shed any light on the situation of timing?
No, not just that I agree with the discussion so far with the phasing, allow a few of the phases to proceed, that's normal, and then at some point in the future decide when and at what time the city would like to provide that access to homes, which is contingent upon that developer's agreement. So that's all I have to say.
Okay, thank you. Mr. Legler?
And I appreciate the clarification there, and Commissioner Box, I appreciate your comments. I think that there's probably one distinction that I'd like to be made, and I understand that this is something that is the subject of further discussion once we get to the development agreement phase, but the distinction really is that this is a new subdivision, and so under the ordinance, Phase 1 and Phase 2 under the current subdivision would have had that access to Markley at the time, and so you wouldn't have needed the second construction access there that they did eventually put in on the southern edge. What we're talking about now is a new subdivision where the ordinance requires access to a perimeter street, and so it wouldn't matter that Phase 1, Phase 2, Phase 3, Phase 4 could go in. The trigger would be when you did Phase 1. So that's going to be my comment there, and I understand that that's fodder for a future meeting, apparently. So
I just want to make clear that any action that is taken today relating to this preliminary plat doesn't authorize the developers to do anything except move forward and attempt to negotiate a development agreement. And if that is successful, then they would have to come back with a final plat, and the final plat would pin down all those details, and we would have a development agreement to work from to get that carried out.
And just, you know, I appreciate our ability to share viewpoints, even though they don't mesh exactly. I would be a little distraught if I believe, Dean, that would be 2030 before that's built out. And I don't know where you live on Stone Post. That's a lot of years of sand trucks going by your house. without a doubt. And unfortunately, the little kids that are in that area now will have grown up and gone to college, and some of those houses will have sold, and more little kids will come in before this is done. So it's kind of mind-boggling when you begin to think about that. I understand it. So.
Well, I appreciate the opportunity. If I can answer any other questions. If not, I'll turn it over.
Yeah,
Yeah.
I have a question. How do you feel about not having parks in your neighborhood?
Well, certainly I think that there's been talk that we would appreciate, we being the neighborhood, some direct access, whether that be on Magnolia to the soccer complex or north to East Crawford, to the dog park, to the East Crawford ball fields. Currently, there's really not a great way to go by foot, by bicycle, without endangering yourself, because you are going up a hill if you're on Markley, and there's curves right there. Speed limit's 45 with no shoulder.
No shoulder.
And so it's very difficult. For instance, if you wanted to push a stroller along that path to get up north. And then the same thing is true once you're crossing the bridge to go to the soccer complex over Magnolia. And so at some point, certainly I would hope as part of some sort of master plan, whether it be with Parks and Rec or through you folks, that we would get access either to the west or to the north.
And just as an aside, the plan for developing a new neighborhood park plan or parks master plan for the community is moving forward. The city commission awarded a contract for that on Monday, and that will be moving forward. And obviously they're going to look at areas in the community that are deficient as to neighborhood parks.
And trails, though, too.
And yes, and our comprehensive plan makes lots of references to linear parks, but we don't really have a linear park system at this time except for the levee trail, and that's the only thing that we would consider to be a linear park at this time.
Thank you.
Thank you, Mr. Legletter. Is there any further public comment? Please. State your name and address.
Steve Rothenberger. I live on 2531 Kaysen. I just want to clarify, I agree with everything the other gentleman brought up here. I want to clarify a little bit on the traffic. Mr. Boxa, your point was well taken, but if you look at the way it is laid out, when it was in its initial infancy and it just had the one exit or the one entrance on Stone Post, there were 3 streets, and when there's 3 feeder streets there, so when they would come in off of Markley, the traffic's divided in 3 right there because it's feeding into 3. Once it kind of filled in and then moved farther south, the part they're finishing now on the entrance to the farther south, that's almost all new construction, and it's all happened almost immediately, so a lot of those houses are empty. Once you move to this next phase 1 and 2, which are going to cover the ends of Stone Post, Ridge, and Kaysen, most of that's going to be coming in Stone Post. I mean, he has a concern there until it gets farther, just because of the way the streets are designed. And looking at this diagram, what would make the most sense at a minimum is once you get someplace in the middle of 3 and 4, which are in the middle of the new section, then it's like by then the trigger should be pulled because, that's the breakover point. Just one question for my own clarification. If you vote to go ahead and change this designation from A1 to R1 so that it moves forward, does that mean if it passes to R1 that the gentleman will not be able to farm it then because it's not classified as agricultural ground? It just sits then until it moves forward?
Even it is
that's at all.
zoned residential and it's not platted or developed yet, there is still a right to farm that property. It's not dependent on.
Doesn't shut it off.
Right, doesn't
then.
shut it
Okay.
off. The other thing is that essentially it's a contingent zoning so that if we never get to the point of having an approved final plat, then essentially that R1 zoning will be rescinded and it will go back to agricultural. The only way that it would actually officially change is if they successfully submit a final plat that meets everybody's approval, including a phasing plan.
Just for my own education, I'd rather look at the wheat field than nothing.
Right.
Yeah, I don't disagree with you at all. And
We're with you on that.
And I do think those phasing things will be something that if an initial plat or preliminary plat is approved, those things in the development agreement, it may come to pass that when it reaches the point where that traffic calmer, as Dean calls it, that may be the trigger. We don't have
And this
that purview to do
phasing
that
plan
here.
is only preliminary, and it's certainly subject to change, and I can't be certain that we may not end up with something here where we have a second connection to Holmes Road that will, help disperse this between Ridge Hill and Stone Post. So this is preliminary, it's conceptual, and what we're trying to do is give a picture that goes with the zoning designation of what could be the layout, but there's a reason it's called a preliminary plat.
Further public comment?
Hi, my name is Phil Van Court. I live at 2524 Stone Post. That would be across the street from Lee. I share some of the same concerns that have already been mentioned. I have a 5-year-old, a 3-year-old, and a 6-month-old child. I'm not opposed. I think Lee mentioned, and I think it's worth restating, I don't think that I'm no more opposed to the rezoning, and I think only have maybe certain concerns as it relates to the construction phase, most that have been shared. Some of the discussion that maybe you just observed and my unfamiliarity with the process would be, I don't know the difference between a preliminary plan and a final plan, but, I would draw your attention back just briefly to the rezoning application. There's a line that caught my attention that's inconsistent with the preliminary plat that I just thought was just worth attention. If you look at the rezoning application, page 5, number 8, regarding streets and traffic, it says, there's about 2/3 of the way down. It says, staff believes the 106 building lots can safely and efficiently be served by 2 access points from the west, which we have, and the access point on Holmes Road proposed on the applicant's plat, and then, but ideally the subdivision should have 2 entrance points on Holmes Road, like Magnolia Hills Estates does on Markley Road. So what's observed in the rezoning application, it just seems a little inconsistent. Maybe that's only because this is a preliminary plat, but I would like to see in a future version that recommendation or, ideal circumstance be given further consideration. I mean, even, just do the quick math. It says, okay, so when fully built, we'll have an extra 1,000 or 1,100 vehicles per day. Well, even 3 entrances versus 4, that's another 100 cars a day down my street that, if diffused and if there's reasonable recommendation or contemplation of 4, I'd certainly like to see an additional entrance and exit on Holmes Road contemplated and, maybe even contingent on 2 Holmes Road entrance and exits. Relative to the timing of the access from Holmes Road, I'd share the same observation that maybe Lee
had, that, if it's a requirement of a subdivision, if it's a regulation of a subdivision to have at least one public street access point on that direct access perimeter street, then it seems like waiting until phase 5 of the build out of this development, that seems inconsistent to me with the regulation for a subdivision having that access in the first place. If it's not hooked up until the very end, why have the regulation in the first place? I would offer just maybe one additional thought along those lines also, because it makes sense to me that you wouldn't want to pave the whole street right away. Maybe I don't want the whole street paved right away. Maybe I want a rock road coming in from homes that's a limited use that prolongs Stone Post being a cul-de-sac, if you will, and we're not necessarily, I wouldn't say we would necessarily advocate that you'd have to fully pave and curb that all the way to Holmes Road at phase 1, nor would that be my interest. I would say if there is construction access in a manner where the road can be improved and the value of that improvement can still be captured when you go finish paving the road. I mean, we're just talking about grading and rock. That seems to serve two purposes. It gives an alternative entrance for construction, traffic, and is consistent with, ultimately what's going to be required of the subdivision anyway. So I think those were the only 2 points that I wanted to make and draw your attention to. So thank you for your time.
Thank you.
Would anyone or Mr. Andrew like to respond to any of that?
Yeah, I would just
Points well made.
differentiate that we have a regulation that requires a minimum of 1, and it is my opinion as a professional planner that it would be preferable, if not required, at least preferable to have a second way in and out to Holmes Road precisely for the reasons discussed, which deals with 1, dispersal of traffic, and 2, it's always better. There's no physical impediment. Some of our properties have a physical impediment that keep you from having 2 ways off of your perimeter street. There's no physical impediment to having a second connection to Holmes Road here. And again, I believe that the primary design consideration was a belief on the part of the applicants as they laid this out that the farther south they put it would minimize the amount of paving that they would be responsible for, and that is not the case. And so given the understanding that that segment of homes has to be paved in any event, then they may decide for their own best interests that it's a better design to mirror the design on Markley by having a second means into Holmes. But that statement in there is based on my personal professional opinion that that is preferable to have 2 ways in from Holmes than 1.
I would agree if through the development process, the development agreement, there is in fact 3,000 feet, and I know I'm rounding that off, of pavement done on Holmes, then as they redraw this preliminary plat into a final, you may find that some of those houses get spun around, because it's not just quite as simple as we're going to draw a straight line out to Holmes and call that a road, because the orientation of some of those homes in there would need to change significantly in order to do that. But if the developer already has to pay for the road, they may find that that's a desirable thing to do. But that's just, at this point, we can just speculate on that. We're looking at what is the minimum requirements.
And the minimum requirement is that they have at least 1 public access point on homes. And the second aspect of that is discretionary, and we do obviously agree that, and made note of the fact that how this is phased, it's going to be very important for the development agreement to address that.
Does the applicant have any comment? Are there any other questions? Mr. Van Horn, you've been very clear and direct in your presentation. I think that's recognized here, and there are other phases to go to. Your presence might be helpful to your cause. Commission, I think, are we ready for discussion? Motion?
I think I'm ready for a motion.
All right.
I move that we approve the preliminary plat, subject to the 12 provisions of attachment 5. On attachment 5, yes.
Okay. That
Just
seems
for the record, condition number 2 is that a final phasing plan indicating the proposed phasing of public improvement shall be submitted with the final plat. And so that is a condition that, as part of the final plat, there will be an agreed upon phasing plan.
I'll second that.
it's been moved and seconded. Is there any further discussion?
I have a little bit.
Me too.
Oh, go ahead.
I just wanted to clarify, Mr. Andrews, on page 11, number 9, it says a lot grading plan or additional information about the plan for addressing rear yard drainage needs to be provided, and it says not yet received.
Right.
And then is that addressed then in one of your 12 conditions? It would be number
Yes.
3?
It is addressed in condition number 3.
Okay.
That once we have agreed upon development phases, then as each development phase progresses, then the developers, design engineers will have to submit a lot grading plan for that development phase as it progresses. And that would be a condition of approval.
Thank you.
We don't have one at this time, but it will be required.
Okay.
And it is my understanding, though, that at the final plat, then we could discuss phasing Stone Post Road and also construction entrances at that time. Is that correct?
That is correct.
Yeah, okay.
And I agree, and the reason I'm seconding this and going to vote for it is that we're going to bring these two entities to the table and begin some serious discussion. The biggest hurdle, long before phasing and long before some of those other things, is streets. What's going to happen to homes and how much of homes is going to be improved? And if we don't bring these groups to the table, that big elephant is going to remain in our living room forever. So I'm really excited about this. I think Mr. Andrew listens very carefully to discussion from here and from there, as well as the minutes, and I'm sure the developer is listening as well, and those things will be at least considered as that final plat is developed, so that when it comes here and you all come back, you'll say, oh, they listened to us. There are some of the things that we talked about taken care of, and that's the whole beauty of this whole process, I think. So I'm sorry, I politic too long for that.
I see City Council standing. Does the council want to approach to comment on this issue?
Thank you. Greg Binkson, Clark Meisel Linville, legal counsel for the City of Salina. And I'll begin with an apology for a little bit of staffing that we need, that I think we need to be sure we're all on the same page. And that has to do with the chicken and egg. And I'll certainly defer to Mr. Andrew, but wanted to at least raise the question. And as you know, Deputy City Manager Mike Scragg is with us as well, as we anticipate this first time under the new ordinance and the steps that everybody is trying to carefully take and properly take. anticipating that you might approve the subdivision, the preliminary plat, such that it would go forward, and the need for discussion and development of this development agreement. The question that I had that I thought hopefully is appropriate to raise, and that is most likely to Mr. Andrew, as we look at the access criteria, we've discussed that there is, of course, the minimum requirement. There also is reference to the additional means of street access, and then there are criteria in the code section that address the considerations to be undertaken as far as any additional access requirements. Is there a concern at all, Mr. Andrew, as to whether the City Commission's job, assuming adoption or approval of the preliminary plat, that if there is a sense at the Planning Commission level that there should be additional access points, particularly as they would relate to homes, and I guess I'm looking to Mr. Scragg as well, as to whether, as that advances to the City Commission, that the City Commission would be very interested if, in the viewpoint of the Planning Commission as to that, as to any further direct access?
Why that would be
At this stage?
Well, I guess the reason that it wasn't considered significant at this stage is that, again, this layout was developed based on the belief, I believe, from the developers that by having this as far south as possible, that they would not be responsible for any improvements to this abutting section of Holmes Road. And so that was the primary driver behind this, and not necessarily looking at all the aspects of it in terms of desirability. We don't know whether, we don't know whether that is feasible, but in my conversations with the developers, this was put as far south as possible in order to minimize the length of Holmes Road that might have to be paved or improved. And in the end result, that is not going to be a determining factor on what portion of Holmes Road has to be improved. From the City Commission standpoint, whether there is one access point or two is not going to have any influence on the improvement of this section, because it's still going to have to be improved as part of the development of the subdivision under the subdivision text amendment as it was adopted. So they are responsible for the abutting portion, the 1,147 feet there, and also for the connecting portion, the 1,247 feet there. And it's not dependent on the number or location of connections there.
And without presuming the viewpoint of the Planning Commission, if the Planning Commission on final plat was of the opinion that the second or additional access was required, that would be viewed as the time to address that?
There would always be an opportunity, and it's not unusual for a final plat to have some tweaks or adjustments compared to the preliminary plat when the infrastructure and some of those things are more ironed out. It would not be unprecedented. I guess if it's important to you that there be something on the record as to their preference of that, then that would have to be in the record and then formally communicated to the applicant. But there's also a requirement that it be based on some technical requirement on technical considerations, and the reference there is to, it refers to engineering judgment. It doesn't refer to planning judgment, but I am merely stating from a professional planning standpoint to have the second access consistent with the 2 access points on Markley is consistent with the planning principle of trying to disperse instead of concentrate traffic.
Just in
And
the...
it says, as determined necessary on the basis of technical analysis and supported by application of professional standards and guidelines. And as a professional standard and guideline in the planning field, it is, unless there's some physical barrier, it is always preferable to have a second means in and out, both for emergency access and dispersal of traffic.
And I would like to say, just in the role of chair, that since we are not going to be voting to make a specific recommendation, that's not our place here, it might be helpful to have just a sense of the commission, and I think that we could do that informally. Now, I'll stand to be corrected by either commissioners or Mr. Andrew if that's out of protocol.
Mr. Chairman,
Yes.
let's see. Who was the motion, the original motion maker?
Mr. Baffa,
Baffa
Commissioner
made a
Baffa.
motion.
Commissioner Roth. And I seconded that, but I'm going to throw this out, and the way to do it is to throw it out there, and if nobody wants to do it, then we vote it down.
Right.
Mr.
What I
Buxton, Mr. Chairman, I'll step down.
Okay.
Again, my purpose was not to affect outcomes, but just to make sure we were all progressing on the same page. So, thank you.
And
Mr.
what,
Maxton.
if I can refer you to your packet, and the very end of your packet as to this item, the items that Mr. Bankston is referring to is on page 502 of the excerpt of the subdivision regulations. And it, as to the additional access points, it says that those are it's supposed to be in order to ensure the safe and convenient movement of traffic within the subdivision and between adjoining subdivisions, the safe and convenient movement of traffic to and from the subdivision via the existing and proposed system of thoroughfares and dedicated right-of-ways, and 3, access to and within the subdivision for fire and other public safety vehicles and equipment in accordance with applicable law. So what Mr. Bankston is saying is that if there is a position among the Planning Commission members or a preference that the final plat have a second access point on Holmes Road, then it would have to be based on your belief that that would assure the safe and convenient movement of traffic within the subdivision and between adjoining subdivisions, that it would improve the safe and convenient movement of traffic to and from the subdivision to the existing and proposed system of dedicated right-of-ways, and that access to and within the subdivision for fire and other public safety vehicle equipment would be improved with the second access point.
Mr. Baffa, my question to you, when I start out with, is would you entertain an amendment to your motion that would include a 13th, I hate to do that, a 13th condition on approval, and that condition read somewhat as follows, that a second access be developed on Holmes Road for the purpose of safe and efficient movement of traffic, period. And that would become the 13th condition along with the 12 that you referred to earlier.
Before I answer that question, I would like to know the impact if Fox Ridge Run, I believe that's what it says, was extended all the way to Magnolia. How would that change the flow of traffic? And that would be phase 7 or 8, I guess.
It might further disperse the traffic, but again, that's of an unknown. It's not known whether that will actually, not only when it will occur, but if it will occur. And what we have is a proposed plat that's in front of us today, and that is not before us today.
So in answer to your question, Commissioner Baxter, then, yes, I would entertain an addition.
Okay. Does everybody understand then what I think my understanding of Robert's rules is that if a friendly amendment is offered and the original person agrees to that, then that becomes the motion. Is that reasonable? I'm looking at people who know that. Or do we need to vote on that amendment before we vote on the motion?
I would defer to Mr. Bankston
Yeah, I'm
whether
looking
that
all over
was
the place.
his what
Yeah,
the point he was trying to raise.
My assumption of Robert's rules is we vote first on the amendment. Mr. Banks, did you have an opinion about that?
I don't believe the friendly amendment appears in the technical version of Robert's rules. It's
Well, I don't
it's used quite often.
I don't
and
have
it-
a Robert's Rules book.
And usually it works nicely. The technical answer, I believe, is that
Need to
there
vote
should
on
be
the
a
amendment.
motion
Okay.
to amend the primary
Okay.
motion.
All right.
All right, so we're counting that as a motion to
Well,
amend
no,
the
I will
primary.
make it formal.
right.
I make a motion to amend the original motion, adding a 13th condition stating that an additional access be made on Holmes Road to help ensure the safe and efficient flow of traffic.
Is there a second to that
I'll
amendment?
second that.
It's been moved and seconded. Is there further discussion? If not, all in favor say aye.
Aye.
Opposed, same sign. Motion carries.
Now
We
we
are
have
now
no,
open
We've got the
for
motion.
now
an
we have a-
original motion. Would you like to restate?
well,
Or maybe you don't need to restate that.
no, I don't think so because it's already on the
That's
floor.
right. Yeah, that's right. You don't need to restate it. So it's
And-
been moved and seconded that we approve application P15-3 with the now 13 suggested
No, the conditions.
conditions. Is there any further discussion? If not, all in favor say aye.
Aye.
Opposed, same sign. None heard, motion carries. Thank you. And thanks to the public for being here for comment. And to the applicant.
I'll leave it to you to decide whether you would like to take a quick break before you get to public hearing item 3.2. But
Yes, I think we'll take a brief break for bladder easement and other purposes.
That's too much information.
No, you said that, no.
Talking about
3.2.
Well, that's
Yeah,
I was thinking
popular reference.
devil or angel.
Oh, I know.
We could have a 50s night.
Great. All right, we will call the City Planning Commission back into session, and we'll look at section, application 3.2, number 3.2, application Z16-6A, filed by the Salina City Planning Commission requesting an amendment of Article 10 to add a new section 42.50 to set out the purpose of Salina sign regulations, and then to amend three sections 42.506, 7, and 8 pertaining to classification and definition of functional, structural, and temporary signs, and finally adding a new section 42.511 to add a substitution clause to allow non-commercial messages to be substituted for commercial messages. So, Mr. Andrew?
I'm not sure if you're remote or if you're
Was your mic
microphone.
on when you were, is the green light on?
Testing, 1, 2, 3. It may not be. Do we have microphones? Test, 1, 2. I'm getting nothing.
Yeah, my mic's not acting
Hello,
like
hello.
it's...
Tell
Okay.
her. Test, test. Is,
Now,
are we coming
now
through?
mine's back on.
Do I need to repeat all that? Okay, thank
Okay.
you. We are assured by the technical people, thank you very much, that we're on. So,
So we
staff?
just want to lay, the way we're going to format this is that I'm going to give you the history of the regulation of temporary signs in Salina. Then Mr. Martin's going to give you the legal principles that form the basis for our proposed text amendment. And then I'm going to talk about some of the planning principles involved. But we wanted to point out that prior to 1988, our sign code was silent as to the use and placement of temporary and mobile signs. So in 1988, the Planning Commission initiated a text amendment to add a section 42508, which was labeled as a temporary sign section, but mostly made reference to what was referred to as decorative business signs, and it was designed to address things like banners, flags, balloons, advertising for special public events, and mobile signs. There were multiple public hearings. They were very largely attended public hearings back in 1988, and the thing I wanted to point out there was that the action took place in 3 different categories, but what I indicated there was that the intent, the Planning Commission essentially made statements or reached conclusions or findings related to what they believed was the purpose or justification of those individual sections. So as you will see in the regulations that they came up with for decorative business signs, they believed that limited use of such signs could assist businesses in notifying customers of special events and sales while avoiding visual impact of continuous use because they were in fact temporary. As for the public events, the Planning Commission thought that there was a public purpose served by informing and directing participants to public events and civic activities. And as to the mobile and temporary signs, there was a belief that having mobile signs intermixed with existing ground and pole signs could distract motorists and reduce the visibility of motorists and pedestrians. In addition to traffic safety, the Planning Commission was concerned that the proliferation of mobile signs could create visual clutter along the streets. And so as we get further into discussing what public interests are advanced by these various regulations, I just wanted to summarize for you. Those were some examples of conclusions or interests that the Planning Commission reached in support of those various provisions. There was another amendment that was done in 1996, and essentially we've had the same regulations in place since 1996, and we indicated to you that based on advice of the city attorney, we believe that our temporary use or temporary sign provisions had some things that could be construed as being content-based regulations. And so what we've attempted to do is, based on the Reed versus Town of Gilbert case, work towards trying to create a level playing field for all forms of temporary signage that are based on size, location, and appearance, and not on the message or content. And then the other aspect that was discussed was the fact that we did not allow for the use of feather flags except for specific events such as going out of business or grand openings. And so there was a desire expressed to increase the opportunities for their use beyond what was currently provided for in the ordinance. So that is part of this amendment as well. And as far as the Reed decision and how it influenced and the legal principles that it's trying to advance, I'm going to turn that over to Mr. Martin. He's going to talk to you about the legal principles and analysis that form the basis for our recommendation.
Thank you, Dean. So as Dean mentioned, there are several amendments being proposed to the sign code, all of which, or most of which, relate to temporary signs. And I wanted to speak a little bit at the outset regarding some of the legal principles that either required these changes or that influenced or restricted how we could address the changes. And as you know, signs are a form of speech, so anytime we are regulating signs, the First Amendment is implicated. And sign regulations must satisfy certain requirements to avoid being characterized as an unconstitutional infringement on free speech. If our sign code is ever legally challenged, the level of scrutiny applied by a reviewing court will depend on whether we're regulating commercial speech or non-commercial speech, and also whether our regulation is content-based or content-neutral. And I want to talk first about the non-commercial category of signs, which receive the highest level of First Amendment protection. These would include things like election signs or political signs, opinion signs, fundraising signs, things of that nature. So when the government regulates non-commercial signs, the test that a court would apply to determine whether we're acting constitutionally is going to depend on whether our regulation is content neutral or content based. And I'll speak to what it means to be content based here in a moment. But if a regulation of non-commercial speech turns out to be content based, it's subject to what's called strict scrutiny by a reviewing court. And when a court applies that standard, it's almost always likely to result in the law that's being reviewed being struck down as unconstitutional. And specifically to pass the strict scrutiny test, the government has the burden to prove that it passed the law to further a compelling government interest, which is a very hard standard to satisfy, and that our law is narrowly tailored in furtherance of that compelling interest. So on the other hand, if a sign regulation is content neutral as opposed to content based, the court applies a much less rigorous standard of review, and the regulation is likely to be upheld. So we know that content based is generally not good, likely to be struck down. Content neutral is much better. So how do you tell if a regulation is content based? Up until last year, most courts looked at whether the government was singling out a particular viewpoint or whether the government was motivated by disagreement with a particular type of speech or message. So under this approach, it was generally recognized that cities could create different categories and different rules for types of non-commercial signs. So, for example, cities could say that political signs can be displayed during certain months of the year, but not others, while at the same time having regulations that said fundraising signs can be displayed year-round. That was viewed as okay, and those weren't viewed as content-based because they didn't single out different viewpoints. We didn't single out different political parties. We didn't single out what types of fundraisers could be advertised. So that's how the law used to be, and that's changed in 2015. As Dean mentioned, the United States Supreme Court decided the case of Reed versus Town of Gilbert, which redefined how courts look at whether a law is content-based. So after the Reed decision, the new rule is basically that if a code enforcement officer has to read a sign to tell if a particular sign code provision applies, then the sign code is content-based. So since you have to read a sign to know whether it's a political sign or to know whether it's a fundraising sign, those are all now content-based regulations, even though we're not singling out viewpoints. So it's a much harder standard to satisfy. So Salina's current sign code, as with pretty much everyone else's in the country, or most others, we have some provisions that would now be viewed as content-based under the Reed decision, such as exceptions to permitting and some size restrictions on political signs and opinion signs. So these would now be subject to strict scrutiny, which, as I mentioned earlier, means that they would likely be struck down. So that's what it means to be content-based. The converse of that is a content-neutral law. Content-neutral laws would include things like size limits or spacing or quantity or allowed locations like specific zoning districts, setbacks, things like that, maybe materials, lighting, structural forms, things that apply regardless of the type of message you're displaying on a sign. So those are content neutral, and as I mentioned earlier, those are kind of where you want to end up if possible. They're much more likely to be upheld by a court. So to bring Salina's sign code into compliance with READ, we've worked with staff to prepare a text amendment that takes us in the direction of deleting all content-based regulations applicable to non-commercial signs. The content-based categories would be deleted and merged into a new category called temporary signs. The category of temporary signs would then be regulated with content-neutral regulations, such as how many you can have and where you can have them and how big they can be. So most of those changes, which Dean will walk through here in a moment, are shown in the proposed text amendment to Section 42508. And we've created some proposed new definitions to go along with that text amendment, which are shown as amendments to the existing definition section in 42506 and 42507. So that's how we're dealing, and we're proposing to deal with the category of non-commercial signs. And I would note that the Reed decision applies solely to non-commercial signs. Moving on to the category of commercial signs, the proposed text amendment also contains some changes related to this category. And commercial signs are also protected by the First Amendment, although to a lesser degree. A sign is a commercial sign if all it does is propose a business transaction or if it relates solely to the economic interests of the speaker. I think we all know it when we see it, but some categories that are commercial signs that you might not expect would also include real estate signs, open house signs, garage sale signs. Those types of signs are also commercial signs. So when the government regulates commercial signs, a court will review that regulation not by applying the strict scrutiny test that I discussed earlier, but it would apply what's called the intermediate scrutiny test, which is easier to satisfy, but we also don't have a free pass. So that's a three-part test, and under that test, the government must, number one, demonstrate a substantial interest to be achieved by our regulation. Number two, our regulation must directly advance that substantial interest. And number three, our regulation must not be more extensive than necessary to advance the interest. And generally, with respect to the first part, demonstrating a substantial interest, it's well established that cities have a substantial interest in regulating traffic safety, aesthetics. Those are well recognized and the most common substantial interests at play when we're talking about regulating commercial signs. Dean spoke to what interests were implicated when some of the sign code provisions went into effect in the past, and I think they're consistent with the traffic safety and aesthetic considerations. Most cities, including Salina, have regulations that distinguish between commercial and non-commercial signs. An example would be we generally prohibit advertising signs in residential districts. That type of regulation would satisfy intermediate scrutiny because the city has a substantial interest in minimizing the aesthetic and traffic safety issues associated with commercial signs in residential districts, and prohibiting advertising signs in residential districts would obviously directly advance that interest. So we can generally distinguish between commercial and non-commercial signs, but when we start to make content-based distinctions between various categories of commercial signs and what types are allowed or disallowed, we need to make sure we do so in a legally defensible way. This is most likely to come up where we have a blanket prohibition of commercial signs, but start to make certain exceptions that are based on the content of the message. To pass constitutional scrutiny, each exception to a blanket prohibition should be supported by a substantial governmental interest. That is at least as important as the interest that motivated you to prohibit the commercial speech in the first place, whether it's traffic safety or aesthetics or something else. And we should also make sure that any exception isn't broader than necessary and that it's narrowly drawn so as to interfere as little as possible with the ultimate objective. So that relates to one of the issues that we'll need to talk about during today's hearing, which is how to deal with the potential display of commercial messages on temporary signs in residential districts. When Dean walks you through the proposed text amendment here in a moment, you'll see that the language that we're proposing would allow each property owner to display a certain number of temporary signs on their property. The definition of temporary sign is inherently content neutral. So when we say you can have a temporary sign, we're not telling you what you can what message you can put on the sign, and it would allow the property owner to display any message. The text amendment does say that in residential districts, no temporary sign may display a commercial message. There are certain types of temporary signs that are commonly displayed in residential districts that are commercial in nature, such as real estate and open house and garage sale signs, and even construction signs. So a blanket prohibition of commercial messages on temporary signs in residential districts would have unintended consequences. And we've addressed this in the draft text amendment by keeping the general prohibition on commercial messages on temporary signs. But the text amendment contains several potential exceptions that you may wish to entertain for certain content-based categories. We've provided these sample exceptions for discussion purposes. And as we walk through the text amendment, we'll want to talk about each one in particular with the ultimate objective of, if any exception is approved, we need to be able to articulate a substantial interest for making that exception. So we can talk more about the various exceptions and a potential framework for addressing each one if you would like. But generally, that's how we're addressing non-commercial and commercial signs as they relate to temporary signs. One other aspect that we're proposing an amendment for is the addition of a substitution clause. This would be a proposed text amendment that goes in section 42-511. The reason for this is that case law makes clear that a city cannot treat commercial signs more favorably than non-commercial signs. So anywhere that we allow a commercial message, whether it's a billboard or any sign, we also have to allow a non-commercial message to be displayed if the sign owner wants to display that. Otherwise, we would be regulating non-commercial speech with a heavier hand than commercial speech. So the substitution clause attempts to preempt any issues there by basically saying that non-commercial copy will be permitted on any lawful sign, which will help to prevent any sort of inadvertent commercial favoritism that could get us in constitutional trouble. So I think that covers generally the legal reason for the proposed amendments. There's lots of policy decisions, some of which you'll have discretion. Other amendments, you don't have a whole lot of discretion, and we'll try to point those out when we can. If there are any questions about any of that I just talked about, I'd be happy to answer it now or talk about it as it comes up. Otherwise, I'm going to turn it back to Dean to introduce the specifics of the proposed text amendment.
And what we've tried to emphasize, and we're certainly not done yet, but our sign regulations, just like about every other sign code in the United States, has regulations that vary by the category of sign, and the sign is basically defined by the type of information it conveys. And what we're trying to do is move away from that and focus on the physical characteristics of the sign. And the physical characteristics include the number of signs, the height of signs, the size of designs, the design characteristics, the location of signs. All of those are fair game where you have discretion over, and those, when we talk about options and getting direction and feedback from you, those are things that are within your purview as to the total number of signs, what the maximum size, height, those types of things should be. And so what we have done is we have drafted a proposed purpose section. We have taken the first portion of the text amendment and proposed some clarifying amendments, and we're proposing to delete categories of signs like non-commercial opinion signs and political signs and real estate signs, and substitute for those the broader definition of temporary sign. And then we're also proposing to define banner sign, feather flag, inflatable sign, and yard sign. And those definitions refer to physical characteristics of signs or structural types of signs instead of functional types. So the first item that was discussed is that our sign code lacks, in many cases, a reviewing court is going to look to what the community cites as what are the reasons that your community is attempting to regulate signs, and this does not substitute for trying to identify specific governmental interests as to the various exceptions that we're going to discuss, but this is kind of the overarching purpose that cities would go back to say, what are you trying to do in your purpose of regulating signs? So we have discussed this before, but you can see things like references to pedestrian and traffic safety to protect the aesthetic appearance of the city's natural and built environment. Some of those relate to safety by not having unsecured signs or things that are poorly maintained. And one of our goals is to provide for the placement of temporary signs without regard to the communicative content of the sign, to provide consistent design standards that enable fair and consistent enforcement. And then the other aspect is to preserve and protect the city's ability to maintain its public right-of-way, and that refers to the prohibition on locating these signs within the public right-of-way. So, John, I'm going to ask you to go ahead and go to the amended section 42508 with highlights. And what we've attempted to do is give you the full meal deal here and have a base plan, and then to have options on top of that. And we may need to blow that up slightly, John. So items 1 and 2 there are basically your base allotment, and what we've tried to do is distinguish in item 1 between signs that are placed on individual residential lots in our residential districts. And basically we're saying that if you are the owner of an individual residential lot, you by right may have 2-yard signs that can't exceed 6 feet in height or 8 square feet of combined sign area. And we're not going to tell you what those are, if it's Bowl for Kids' Sake or promoting a vacation Bible school or any of those types of things. That is a right that goes with your individual property right to have those 2 signs. Item 2 there is the base allotment for all other types of lots, which could be characterized as commercial lots, but we also have apartment complexes, assisted living facilities, nursing homes that are in residential districts but are not on individual residential lots. And so we're proposing a base allotment there of 2 freestanding temporary signs, and then the size is up to 32 square feet of combined sign area instead of the 8 square feet, which is on an individual residential lot. And so that is the base allotment, and if you are satisfied with that, that is, we believe, defensible. But the other thing that we tried to do in developing this is to look at what existing practices and circumstances there are within the community. So we have these options, which basically say, in addition to the base 2, you can have extra signage during an election season, and would allow up to 4-yard signs not exceeding 8 square feet each may be placed and displayed for a period of up to 45 days prior to an election, and then removed within 7 days following the election. We also have an option, and again we discussed that it's important that you articulate justifications for what would allow these are essentially commercial message signs to be located in individual residential lots in residential districts. And so again, it's the 8 square feet if you're on a individual residential lot, up to 32 square feet on a commercial lot, indicating that that property is on the market for sale or it's available for lease. There is also an option there for allowing existing or extra signage for an open house or garage sale sign. And again, it would have the 8 square foot limitation, and we're proposing it could be placed 2 days before and must be removed the day after the sales event. And then option 4.1 there is the option of having extra signage for construction. And then that would allow it for both on an individual residential lot and on a commercial lot. And if you drive around the community and you drove by the ComCare site or you drive by South High, our code currently allows the placement of a sign up to 32 square feet that tells you who the contractor is, who the designer is, the name of the project, those types of things, and those are posted on construction sites. One of the options that we have given you is to allow an individual homeowner who is having a roof put on by ABC Roofing or having gutters put on to allow the placement of a sign for that business in their yard during the process where that is occurring. That is, it's not uncommon practice for businesses who are painting homes or putting on gutters to ask the homeowner to put a sign in the yard indicating that. And then the variation of that is option 4.2 that would allow that, but only for the commercial lots and not on an individual residential lot. So those are essentially the options for extra signage, and then the other sections there deal with the off-site signs there for real estate, for open house, and for garage sale. And so it is not, our code today does not affirmatively make an allowance for you to go place a garage sale sign or for a realtor to place an open house sign on a lot other than the lot on which the event is taking place. And so that is one of the options there. It would, what Mr. Martin would refer to as, or we refer to as an off-site or off-premise sign. And so your justification in terms of that being a right that goes with the ownership of a property is not quite as strong as it is allowing the sign to be placed on the actual property. But it is not uncommon in Salina to see signs placed on a corner lot that direct people to an open house on an interior lot, or a garage sale on a corner lot directing people to an interior lot. And so we're providing that as an option to be included in the text amendment, but as Mr. Martin indicated, if that is a amendment that we want to include in as an option, we would need to kind of walk through each one of these, and we want to get a sense of you whether you would like to include that in the text amendment, and then also we would try to work with you to see if what governmental interest allowing that exception would advance.
And Dean, if I could make one quick point of clarification. John, could we go back to subsection 3 on page 1? That was, they're right there. Dean spoke of the base allocation that each owner is entitled to. We had it set at 2 2 temporary signs allowed per property owner, and we are not dictating what type of message can be displayed there. The thought with subsection 3 there was we're still not telling you what messages you can display. We're creating certain triggers that, if satisfied, would increase your base allocation. So under 3A, for example, we're saying that in addition to the temporary signs allowed under A1, which tells you in a residential district you can have 2 signs, during an election season, your base allocation goes up by 4, so you now have 6. The way we're comfortable with that, since we can't regulate content, we're not telling you what you can put on your additional 4. So the thought is we're trying to accommodate what is clearly a desire to put up election signs, but we cannot dictate the content. That would run afoul of the Reed decision. So
So that's just a timing issue rather than a...
That's a timing issue. We're not saying what content could be there. During an election season, if you go with that model, someone could have 6 signs that advertise their favorite fundraiser, and we have to accept that. And each of those subsequent options creates additional base allocations without regard to content. There is a point, and I think it's right where Dean left off, where we say, and that is, John, if you don't mind going down a little bit, that was in subsection C there, right about there. And that is where we say on property in any of those R districts, no temporary sign can display a commercial message, except, and then we have a laundry list of potential options there, spanning from a real estate sign to an open house sign to a garage sale sign to a construction sign. And that is where we are creating content-based exceptions to the general prohibition. And I spoke earlier about how if we do that, we need to have a substantial interest for each of those exceptions.
And then, John, if you could go to the matrix that we developed. And so one of the things that we have to discuss is that, and we're looking at it in terms of from a residential lot perspective, but you get a base of 2 temporary signs. During election season, you could potentially have 4 additional. If you are having an event where you're inviting the public, that would allow you 1 additional sign. If you are, that would include an open house or a garage sale. If you are having your property offered for sale or lease, that would allow 1 additional sign. And if you choose to allow a sign during construction, that is potentially an additional sign. And then we have the question of the off-site or garage sale, the off-site open house or garage sale sign, which potentially is again 1 additional sign. We assume that because we have that during election season, you can have up to 4 signs. One of the other things that we're looking for guidance to you is we have a provision there that is not filled in, and is if you have a position or feeling as to at any one time there should be no more than X number of signs. If you took this and made it cumulative, and you had the 2 base signs, you had the 4 additional signs during an election, you were inviting the public onto the property, you had a for sale sign, and you authorize the ability to have a construction sign, then that puts you at potentially 9 signs. And if we add the category of off-premise, a individual residential lot could potentially have an authorization to have a basis for having 10 different types of signs, but still within that universe, assuming that they're not all occurring simultaneously, you could still decide to have a cap on an individual residential lot that says at any one time you can't have more than X number of signs in the front yard on your lot. But it could never be, that cap could not be less than 4 because we allow up to 4 during an election season. So this is not perfect, but it's designed to show you that if you have your base and then you have these other menu of options that you could, as you add categories, you could potentially add to the total number of signs, but it is within your purview to say, we think in a residential lot, you should not ever have more than X number of signs at any one time.
I could see a corner lot having a for sale sign on both abutting streets, and then that person might want to have 4 election signs. And so I think 6 is more than enough.
I believe that is what we currently have it filled in with. If you look at subsection D there on page 3, we inserted the number 6, but highlighted it because it's within your discretion.
What we attempted to do is what we've highlighted in gray there is all the things where you have a menu of choices. For instance, we talked about 1 sign per property or 1 sign per street frontage. Those are options. The number of days that it's up is options, and certainly the number of signs.
I'm a little, I like the reference earlier to say if you have to read the sign to know it, whether it's right or not, it's a content sign. And I don't know how you could prevent any property owner from not having 8 signs all the time. They, if it happens to be in November, they could be blank, could they not? Or could they just have a question mark on them?
Yes, they can put whatever they want on it if we
so
allow.
But how do you know it's a political sign? You don't, obviously. And how do you know that it's a invite you to your property unless you have to read it first? I mean, it's. I'm finding that really hard to know that we're getting ourselves out of harm's way with content neutral. If in fact we say, if it's a for sale sign, you can have one. That's not content neutral. That's pretty content specific for sale.
To be clear, though, we're not saying, during an election season you can have 4 additional election signs. We're saying during election season you get 4 signs and you can put whatever you want on them.
Okay.
Likewise with open house during construction. The code enforcement officer will have additional work with this ordinance no matter what.
Okay.
It would require them to look and verify that we are in an election season or the property is being actively marketed for sale. So there's no way around that. But we have spent a lot of time trying to make these provisions content neutral.
Yeah, and I'm going to take your word for it. I'm just struggling with that being content neutral when you have to say for sale.
It doesn't have to say for sale. It's just that your justification. I mean, we can confirm whether a home is on the market or not. If you want to have your home's on the market and you want your sign to say "Bowl for kids' sake" instead of "House for sale," that is your decision.
Okay.
But
So
our
if
guess
the enforcement officer were to talk to me and say, that sign is there because I have the ability to have a for sale sign and I chose to use it as
and that is
okay.
why the reference I made and Mr. Martin made to
Gotcha.
subsection D at the top of page 3 is that is ultimately going to be, from a code enforcement perspective, the primary thing that we are going to be able to enforce. It will be the total number of signs. If we go by a dwelling and we get a complaint and there's 13 signs in the front yard, we can say, well, you're limited to having no more than 6 at any one time, so we know that 13 is a violation. And we don't have to worry about what they say. We just have to know that you have 7 too many signs. And then the other aspect of that is looking at the square footage limitations and the heights and those types of things.
This appears to take care of what I think I've heard other people say before, sign farms, where, you know, somebody has an unbuilt residential lot, typically at a corner,
Yeah.
and everybody drops a sign off there. So this does address that, basically, then, even though it is a unbuilt residential lot, the owner of that unbuilt residential lot will be subject to this total. Am I understanding that right?
That is correct.
Okay, good.
Yes.
Because I think, I've seen a lot of those sign farms. I live pretty close to one.
So I think, I don't want to cut the conversation short. You should continue it as long as you want. But I think eventually what we need to move forward and bring you back a final draft would be all of the gray highlighted text. Those are staff's recommendations, and either your concurrence or proposed alternative for any of those gray highlighted areas. Most of them relate to, quantity or size or duration. If you say that looks good, then I think we can move on to another topic here pretty quickly. But there's also some optional language on page 1 where, as I mentioned earlier, during certain events you just get more signs. Those are phrased as optional because you may think, you've already given them enough signs. You don't need more during this particular event or occurrence. You could choose to accept all of them as well. I think probably start by addressing that issue and then move on to the one that probably is most of legal significance, which is the different content-based exceptions that we are throwing out there as options for your discussion to the general commercial prohibition in residential districts. And I can help you walk through that and talk about each one and different rationales that you may have if you want to adopt any of our proposed language.
I think the discussion about the maximum number of signs as 6 makes sense, and that would be in line with our general purpose, number 5, to prevent property damage, personal injury, and litter. Excuse me, I beg your pardon. Number 6, I said, to protect property values, local economy, and quality of life by preserving and enhancing the appearance of the streetscape. Even though during election season I like to put up signs, I restrict myself to 6. Don't want it to be too cluttered.
I was wondering how many.
Yeah. How do we work our way through this? Do we just give you a sense that says we're on the right track? Let's go.
We will go through these and just ask you, for the base and for the options, and see if you believe they're restrictive, excessive, or if you have anything. And then when we get to where we talk about exceptions relating to the signs that might be construed as having commercial speech and granting exceptions for that, then we'll discuss with you what you think governmental interest is advanced by allowing that.
So if I understand correctly, we have this sheet, we've had it in our packet, that says what? And Mr. Martin has outlined several of those. We have a pretty thorough discussion of it and had a chance to look at it in the packets. I wonder if we could just say, if we have any, without going through one by one, if we have any concerns about any of them, and then move on to the exceptions. Does that sound like a reasonable procedure? I'm thinking of time.
Yeah, all we're saying is that these are staff's recommendations, which is can be basically said 8 square foot maximum on a residential individual lot, 32
Right.
square feet on a non-residential lot in terms of maximum size. Do you have any issues with that? That is consistent with what our code does today. Doesn't represent a change.
Right. And I think partly
I think
because
they're good to go.
I think partly because we've discussed this in the past. I think we're pretty much in. I'm assuming we're pretty much in agreement with us.
Well, I think 8, you don't want to have 6 8 square foot of sign in front of your house. That's a lot. I think that should be limited, and
Well,
8 square feet in the
this says
aggregate?
8 square feet of combined sign
combined.
area.
Okay, I didn't see that. I'm sorry.
That's 2 square feet. That's
Yes,
not, that's
that's-
not election signs, so. Election signs are 3 at least, 4.
4, I'm guessing.
Yeah.
But there are some real estate signs that are slightly larger.
But if, and John has, you've got some graphic examples, correct, John? Like, say, from the Taco Bell sign? Not here, the ground signs, the Taco Bell. So this is the typical size we see of a temporary sign. And these happen to be commercial in nature, but a lot of them are promoting some community event. But this, even with the allowance of a combined sign area of 8 square feet, that is going to be the typical sign that you see, both campaign-wise or Bowl for Kids' Sake or Vacation Bible School or those types of things. So what we're proposing as a base is to basically say, as a base, you are allowed to have these 2 signs in your front yard, and we're not going to tell you what they can be used for.
Except those signs are in the right-of-way.
These
I think
are,
they're
yes.
probably not.
We have lots of pictures of signs in the right of way, but that's beside the point. We're just giving you the illustration of size.
That's 8 feet.
No, those are probably about 2 square feet, 2 to 3 square feet.
So perhaps a total of 6 there.
Yes. That banner is probably 32 square feet. And so in a commercial area, we're talking about, when we talk about 32 square feet, we're talking about that. And so that sign is also in the right of way, but that when we talk about temporary signs, that's what we're referring to. So we're not, let's get away from that, John, because we're not talking about feather flags at this time. I just wanted to have some illustrations of the type of temporary signs we're talking about.
No exception for that one.
So when we talk about temporary yard signs, this is the type of sign that we're referring to. And so what we're saying is 2 of these in a typical residential lot and 2 of these on a commercial lot, but they could be larger in size in a commercial setting.
So are we ready to move to exceptions or a discussion of that?
I think really quickly, I was just brought to my attention one point of clarification. If we could pull back up just that first page of the sign amendment, that base allocation of 2 signs, we mentioned that is 8 square feet of combined in the aggregate sign area. Right. It may be worth clarifying, and down in the where we create the potential for additional allowed temporary signage, just scrolling down a little bit, we said that during an election period, 4 additional yard signs not exceeding 8 square feet each may be placed. So there's no governor about aggregate size limitations. I think whatever we do here, we want to make sure that we're not, giving larger signs during an election period that could be construed as favoring election speech over other types of speech. So we may need to clarify that when we come back in a way that we believe is constitutionally defensible. It might be worth, I guess, talking about whether you are okay with the general size limitation on that base 2 temporary signs that you're allowed. Do you like the 8 square foot in the aggregate language? And if so, how do we reconcile that with the additional allowed temporary signage during an election without favoring election signs.
I like the aggregate, and we have 2 for an aggregate of 8, just run-of-the-mill. And if we have 4 election, we should have an aggregate of 16. That would be 4 times 2 is 8 in the
That would
top
be
one.
consistent.
That would be a consistent number. Now, whether that makes sense or not, I could defend that, saying, we had 2 for 8, so now we've got 4 for 16.
Okay.
That would be my suggestion.
And then, and it doesn't bother me 45 days. It doesn't bother me one way or the other, but somebody brought up that between the primary and the actual election is more than 45 days. So do they take them up, put them down, take them up, put them down again, or,
Yeah.
yes, that's fine.
I don't know.
That's fine.
Well, you've got, for everybody who makes it through the primary, you have someone that doesn't. And so you need to be careful about that so that, you don't let the people who didn't make the cut say, well, I'll just leave my sign up until the general election, just for sour grapes.
I think we talked about this before, and the libertarian tendency in me would be to say if they want to put them up, fine, but there's logic even within a campaign to remove your signs until right before. And if you have a primary, a sign, same one for the primary as for the general, there's a lot of space in there between that time. You'd be wise, even as a candidate, to take the thing down,
There
put
you
it back
go.
up.
All right, so
Ignore
we
the
leave
X.
45 days then.
Yeah. It says 45 days prior to an election, so that could apply for the primary and it could apply for the general. It's fairly generous allotment of time.
Most campaigns, I know it's not a campaign sign, most temporary signs may not last that long. I mean, they're temporary, their materials are I don't know how many
past 2
temporary
days, they
signs
wouldn't.
would have survived the
The last 2
45-mile-an-hour
days.
gust the last couple days.
But a well-heeled candidate can replace them at will, so, we're just setting up a time frame.
And if I may, I'd like to take a look at our thoughts on the how to go about sizing and putting size limits on that additional temporary sign allowed during an election period. That may be workable, that proposed approach of just saying 2 or 4 additional signs with an aggregate of 16 square feet. I'd like to look at that and make sure we're comfortable with that, and then we can, at the next meeting, present you with a menu of options.
So I'm thinking about the language of that. We're saying, and let me look at that. Could we say, if we change that, up to 4 additional yard signs with that size exception, which would allow someone to put up fewer signs but more square feet? If we want them to, if you say up to 4 with that aggregate, they would have the option of putting up 2 large signs rather than 4 smaller.
It would provide the owner that opportunity. What I was concerned about is we're not imposing that same requirement on additional signs allowed when the property is for sale or additional signs allowed when
Right.
the garage sale. So I think we would need to be able to articulate, why are we saying you get this size of sign during an election and this size when your house is for sale? That might be problematic. And that was an oversight. I think we can fix that and come back with something that hopefully, some options that hopefully you find acceptable.
Yeah, because we don't want a big sign on somebody's yard.
Yes,
Yeah.
keep it,
Okay.
you like the 8-foot
Yeah.
size limitation.
But not one big sign.
Yeah.
And that's for all temporary signs across the board
Yeah, it's fine with me.
in a residential district?
Well, that would be easier to see if, then you could almost have one template, the enforcement person say,
Yeah.
that sign doesn't comply. It's-
Right. Yeah,
Rather
and
than-
if they're small, somehow their number doesn't bother me as well, but a big sign.
So are we saying
Emphasis
that,
is not to-
yeah, and I'm going to wait.
Yeah.
Mr. Martin, just to be clear about this, You're talking about possibly creating that same additional footage for the election season signs to the real estate and the open house or garage sale? Am I understanding that?
I think they all
correctly?
need to be the same size limitation, yes. And whether that's just saying they all can be 6 or they
Yeah.
all can be 8, I think something along those lines.
Rather than
I-
mixing the combined sign area approach with the
Yeah.
maximum individual sign approach, what he's saying, and I think
Right.
we would concur that if we're just uniform across the board and take the approach of no individual sign exceeding X square feet, whatever you think that is, that's probably the preferred approach, especially when we're talking about allowing an exception that allows a single sign. We can't have a combined sign area for a single sign. We can only have a single sign not to exceed. So
Yeah.
it's best to address it as to a maximum that any individual sign can be.
I understand that, and I don't know that I'm arguing for this, but it could be articulated that in the case of election signs, you are promoting a specific kind of speech to guarantee the right of the people to select their candidates. That said, the people also have a right to buy real estate and to have an open house, I suppose, and put up as much signage as they want. But I still would, I think that language of up to 4 additional signs with that amount, you said 16 feet, correct?
I was just,
Mr. Boxer? Yeah, proportionally, in the case of any of those 3 categories of signs, I think I would like to see that, because people have a right to put a big sign up for a temporary sign if they want to.
well, they do, they
I don't think so.
Well, I know I'm talking to a commissioner who's come down firmly against that kind of thing before, but.
Right, but if the ordinance, if we make an ordinance, they will have the right to put up whatever size sign the governing body ultimately says is the right size. Right now, very frankly, you can put up anything you want. You can park a semi in front of your house with a sign on it, and if it's not enforced, it'll sit there until somebody enforces it. So I think, I think if you can't say it in one sign.
It's not in
you
practice, but
Say it in a
that's-
second sign, and a third sign, and a fourth sign. I used to drive down a stretch of highway in some church, and I won't resuscitate. I won't recite the entire thing, but a particular popular prayer was written on about 14 signs as you drove down the road.
First Church of Burmashave.
And I'm not suggesting that, but you can have 4 political signs. So if you can say, vote for Dave Norland, and they can be nice and big rather than one big sign. So I'm really tight on, let's keep those signs,
In residential
Small.
areas, they should be small.
even though you
I
get
agree.
4 of them.
Yeah.
2 foot.
Yeah.
And
Right.
square.
if
Two.
it's worth pointing out, I just confirmed with Mr. Ender, the current size limitation is 8 square feet. That's what it's been for some time now.
In the aggregate.
No, individually.
An individual political sign cannot exceed 8 square feet, an individual real estate sign cannot. So our mixing and matching of combined area and not to exceed is my fault, because I didn't want to be us perceived as, oh, well, you're taking the existing standard and now you're making it more restrictive. Our goal is to be content neutral, but not to be necessarily more restrictive. But I'm of the belief that if I'm a code enforcement officer or planner, it's a lot easier to have a maximum size for an individual sign.
Yeah.
And the other thing driving this is we bumped the size of real estate signs up because we now have had a recent phenomenon. There's 2 signs up in Ohio, and I will get a graphic for you, but they're called swing signs. And the swing signs they're on a taller thing and they're on an arm, and the square footage area and the height of a swing sign is greater than the standard for sale yard sign. And so we didn't want to draft something that suddenly made swing signs non-conforming because they're too tall or they're too large.
So Dean, if I understood you correctly, there is separate language that deals with the maximum 8 square feet, not in this language. Am I getting that correct?
No, what's been pointed out to us and what we agree is an inconsistency is that you've got the 2 yard signs not exceeding 8 square feet of combined sign area.
Right.
And so we're saying that your 2 signs taken together cannot exceed 8 feet. But then we're talking about having 4 additional yard signs during election season, each of which could be 8 square feet, and that is different than 8 square feet of combined sign area. And what Mr. Martin's saying is that then we're expressing a preference or giving a perhaps not defensible size differential there. So what we're thinking is that we have to have, instead of referring to it as combined sign area, maybe 8 square foot for an individual sign is too large. Maybe it needs to be 6 across the board.
Would you buy 4?
Or 4. That is a discretionary item for you.
For each of those additional 4 signs allowed during election season with real estate, am I getting that right?
What we would
No, just
what we would say is
All of
the
them.
2 yard
Yeah.
signs you can have cannot exceed, no sign can exceed 4 square feet if that's where you arrive at, or 6 square feet. And then you would say that extra signage during the election season, 4 additional signs not exceeding 6 or 4 square feet each may be placed on the property.
Just so they're all the
8 square
same.
feet with 4 signs, that's pretty large. Our typical election signs are not 8 square feet. What we were trying to do is 2 things, is not suddenly make swing signs not an option. And then the second thing is our code currently says that a real estate sign may not exceed 8 square feet and a political sign may not exceed 8 square feet. But our typical real estate and political signs are less than that.
what is the swing sign square footage, Dean?
Good question.
It varies. We've tried to measure that, but we looked at that when we were working on this draft, and absent, I can have John try to Google swing sign and see if we can get an image here,
If
but
there are only 5 of them, I'm not real concerned. If that's the general rule these days, it would be of concern.
You often will see them, a lot will be like I'm going to use some dimensional, a 4x4 piece of wood like this, and a 4x4 like this, like you used to draw the hangman on the blackboard.
Yeah, yeah.
And then hanging from that yard arm is a sign. Now, it's interesting to me is, will the space under the sign be counted as sign?
That's what I was wondering.
Or will the 4x4 that is 6 foot high, will all of that be counted sign, even though it's actually only a pole? That would be a very interesting calculation and one that I'd want to stay away from.
Right.
I believe the assistant city manager may want to.
There it is, that's it.
Ah, that
Oh,
is
yeah.
pretty big. That looks like 6 feet maybe.
Well, yeah.
Well,
Most
you could
realtors
just,
don't want to use those because you got to dig a pretty sizable hole in the yard.
So to Commissioner Box's question, though, we would be counting the actual surface, square foot of surface of the sign, not distance to the ground, right?
yeah.
Yeah.
4 by 2, probably, yeah.
Well, and to help everybody get a feel for it, the fluorescent structures in here are basically 8 square feet. The ceiling panels are 8 square feet. That's the size of the sign you're looking at, vertical or horizontal, and most of the signs you see around Salina right now aren't that big. They're half that.
Yeah.
Well, I think about half. And see, I really don't care what the number is. I just want it to be the same, so that if I were the enforcement person driving down the street, I can go 1, 2, 3, 4, 1, 2, 3, 4, and not go, oops, that one there looks like it might be a foot longer than it should be. We won't have the time to enforce this ordinance.
I was going to mention, I think from a legal perspective, it's going to be helpful just to establish what is the maximum square footage that you're willing to allow on a temporary sign, regardless of what it displays, in a residential district. Keeping in mind, for what it's worth, the current limitation is 8 square feet. but you can do whatever you wish.
Keeping in mind the demonstration sign that Mr. Schrag just brought up, probably about 8 square feet, to eliminate a hassle, that's what's being done. I think we ought to stay with that.
Yeah, you're probably right.
I agree, but what if you have 6 of them? Are we
Yeah,
saying you could
that's right.
possibly have 6 of those?
How about just saying one at that size and all the rest, if you're using others simultaneously, they need to be 4.
Well, there you could have an aggregate, couldn't you? Could you say?
It'd be better
But
to
then
say
the
just the
aggregate, you'd have
first
one big one and
That's
one
confusing.
Yeah.
real
Right,
big one and
yeah.
one real small.
Right.
Yeah, that's
Well,
true.
Yeah,
How
what-
about if we get all, if we just give those, we've given them an idea, they can
That's
come
right.
back,
Good
put the
idea.
language together, and if they have 8 in it,
Yeah.
then all we'll have to discuss at the next meeting is whether we want to change 8 to 6.
What we
Good
want to
idea.
articulate is that today, it was not that way before, but today, there is no limit on the number of political signs that you may place in your front yard.
Right.
So if you
Right.
want to put 24 political signs in your front yard, you may today, and this would actually establish a numerical limit. So from
Right.
that standpoint, it is more restrictive, but we also think it's more enforceable and defensible because it's the easiest thing to do from an enforcement standpoint and says, the Planning Commission, City Commission says no residential lot can have more than 6 signs at any one time, and we see 20 signs in your yard, so you are in violation.
With the idea in mind that we may make this meeting last until way past
Yeah.
bedtime,
Yeah, right. It's
more
like
substantially,
woman goes in
more
my youth.
substantially, I would like to throw out and make some discussion about the idea. In my little world, I would like to dissolve it, option 4.1, and have no construction signs in residential areas, period. You know, and as a property owner, I know I'll always have the right to tell my contractor, no, I understand that. But I just think that's distasteful, way beyond political signs, way beyond anything else. They're already charging that person a substantial amount to do their work, and then they're advertising. I think, and I'm talking residential, not the signs that say Central High School has this big construction project, or ComCare has this
Yeah.
construction project.
Yeah.
I'm talking about Joe Blow, who's getting his roof done. I hate that.
I understand what you're saying, but I'm interested in doing some landscaping, okay?
Buying
I
that in
drive
the
around the
paper.
I drive around the neighborhood and see what yard I like the best, and I call that contractor up because he's got his sign out there.
Well, go knock on their door and say, hi.
Well, so I want to say, as a person who
That's my bias.
as a person who sees the no more regulation mania that's going across the country, I come down on the other side of that because regulations are protection. So that's me on the one hand. On the other hand, I know of contractors who have worked for us, independent small business contractors who are trying to let people know what work they do. And similarly to what Commissioner Buffett talks about, they can see the work. And that's the way they have of getting it out. It's an economic hardship for them to advertise a lot. If people see their work, that's all right. So I'm for keeping it in.
Well, but I'm thinking that, I guess if you drive by and see a sign that you like, you're still going to talk to that homeowner and say, were you satisfied? Not just because somebody you admire or you think is smarter than you put that sign
That's
up.
true, Commissioner Boxa, but we are also talking about protecting citizens' right to free speech. That's what we're balancing.
This is
Yeah,
this is not
government regulations,
commercial.
et cetera.
This is residential. Okay,
Yeah,
well, fine. We can't
acknowledged.
agree on that one, then. We're going to have to vote on that.
Well, then,
Two hands.
Jerry, then if a realtor wants to put up a for sale sign, it should just say for sale and a phone number without the name of the real estate agency.
You about got me there. I don't have a good comeback on that one.
So
Except
not,
that realtor is doing that homeowner a service by letting people know their house is for sale. Now, yeah, you may notice that there's minute difference there, but
Sometimes there's a
I'm getting
discount.
tired. I probably vote for anything right now.
So what Aaron and I are discussing is you're kind of free-ranging on those options, but if we went down those 4 options and we worked with you to try to articulate a public interest that's served by allowing those exceptions during that period and see if you can reach a consensus on what public interest is being advanced. So does all the 6 of you agree that there is a public interest advanced by allowing extra signage during an election season?
Yes.
Yeah.
Yes.
And what do you think that public purpose is? Allowing an individual property owner to express their personal opinions and preferences? Or does it go beyond that?
Or education, too.
It's a democratic right, I guess. You know, an election is in our best service. The more people involved, the better.
No, I think you're right. I think you're right.
And I just talked with Ian. I think probably those are content neutral, really. So I think we're probably in pretty good shape with just allowing temporary signs. You can put whatever you want on them. I think we need to run that drill that Dean just mentioned. If you're ready to move on to it, just on the next page, under subsection C, where, okay, so we say in a residential district, this is all we're talking about, no temporary sign allowed under subsection A, which is where we tell you how many you can have, can display a commercial message, except for the following. And then we have 4 different options for you to consider. And again, these will be carving out exceptions to allow a particular content-based category of commercial sign. And this is where, as we move down the list, and I'll talk to you a little bit about it in advance, but we need to be able to articulate a substantial interest to the extent you want to make each of these exceptions. And within each of these exceptions, you have the issue of on-site versus on-site. So when we talk about real estate signs, we want to allow that. We're talking about both on-site, so do you want to allow a person who's selling their house to have a real estate sign? I suspect that you may look at that differently than whether you allow off-site real estate signs in a residential district. But we need to talk through each one of those issues. It might be helpful to note that there is a Supreme Court case that said that governments cannot prohibit for sale signs in residential areas. They didn't speak to off-site signage, but basically the court found, this is the United States Supreme Court case, found that the substantial interest is so compelling in allowing a person to put a for sale sign for their own home that government, as a matter of law, just cannot prohibit it. And they also looked at, it's a very unique medium that is very unique to the message that's conveyed. There are alternative venues to say that your property is for sale, but really the on-site for sale sign is very unique in that the others really aren't even in the same category. So I think as we move down the list, the real estate sign, I would imagine you would want to accept that from the general commercial prohibition. You have a very strong case to do so. I think it'd be helpful to just talk through your substantial interest as we make each of these exceptions. There isn't any case law about open house and garage sale, but I think an argument could be made that those are so intertwined with home ownership, much like the on-site for sale sign, that there is a substantial interest in allowing those types of signs, but not others in a residential district. I think you need to kind of talk through the on-site versus off-site distinction as we talk through each of these. And it might be helpful to point out that currently the code does not allow off-site real estate signs or off-site garage sale signs or off-site open house signs. And I'm looking to Dean to confirm that, but I believe that's currently how the code is written.
We're not saying it doesn't occur, but our current code does not authorize that.
So I would be happy to facilitate, walking through each of those and helping you talk about it, or if you just want to talk about it amongst yourselves and we can listen and chime in, that's perfectly fine too.
I guess on that first, the personal, or the for sale sign, I don't know, my feeling is that an individual should have a right to market their personal property as a compelling interest.
That would apply
And you
to a
could
garage sale.
possibly take that to a garage sale
Yeah.
as well. And then we've got some subsequent ordinance already that talks about how long or how frequently you can have a garage sale. But I just think, we're not talking about a cottage industry where you're selling commercially out of your house here. We're talking about.
Our code
personal-
allows you to
personal
conduct
property.
2 garage sales per 6, or 1 garage sale every 6 months.
I knew there was some magic number there.
Are we allowed to do that kind of a thing, that an exception can be that detailed?
We're talking about
Yes.
signs, not how,
Yeah.
Right. That, what we're trying to show is that what you're pointing out, Mr. Box, is it's not a regular recurring commercial activity. A garage sale is allowed once every 6 months, which means that it's an event, it's not an ongoing activity.
And I'm just going to keep throwing stuff out here until, if you look at I'm going now to the political ones, or I skip it already?
We're talking about the commercial exceptions.
We're on the second page of the proposed text amendment under
Oh, at the
subsection
top.
C.
Bottom, yeah.
Page 2
These
or
are all
page 3?
residential.
Page 2.
Yeah, at the bottom.
Yeah.
These are, what this is saying is that they're not allowed to have a commercial message or be advertising signs, and these are the exceptions to that, which are real estate, open house, garage sale, and the previously discussed construction sign option.
Those look good to me, and you also have the time limitations for construction signs, which prevents abuse, I think, of that.
I think that one's the least justified. Yeah. But
It's,
I'm okay with it,
That's a
though.
new development. That was not true 10, 15 years ago. I don't think much at all. Is that right?
It's not extremely common. It's a fairly recent phenomena, but what we would advise you is that when you go to that particular exception, you are essentially allowing a property owner to advertise or provide information about a business that it's the property's for sale, the garage sale's occurring there, the open house is occurring there. There is a construction activity occurring there, but you are promoting something that is off-site or off-premise. And so the question would be, if I can have a sign for ABC Roofing, what is your justification for telling me I can't have a sign for ABC Restaurant?
Yeah, yeah, right.
Because that's my
Just
favorite
a-
restaurant, and I would like to promote that in my
well,
yard.
there are some interesting things that are in there that kind of make the heartburn go away a little bit, and that they have to have a building permit.
Right.
So if ABC Roof or a landscaper
Right.
does something, puts a sign up, he doesn't have a building permit.
Right.
What about those real estate style signs for
Yes.
new construction? Is that kind of a gray area?
Well, that, and you need to decide that one thing that is commonplace, while a lot of our focus is on an existing established home that might be having a roof or gutters, then you also have the case of a new home that's under construction, it's in a new subdivision, and ABC Contracting is constructing that home, and they want to be able to communicate to the public that they are the ones constructing that home. So you need to, as we discuss that particular construction sign option, and we're talking about an activity performed on the property, while putting one up for my roofing or landscaping contractor might not be extremely common, it is extremely common for someone who's a home builder who's constructing a home on an individual residential lot to want to put a sign out that says home being constructed by ABC contractors.
I wonder if that's more likely to be the case when it's a spec home and it's really a for sale sign.
Usually go
They're
hand in
all
hand.
for sale.
If it's for sale, then it would, I mean, it may be a gray area, whether, is it a construction sign or is it a real estate sign?
Right.
It could very well be a real estate sign if it's
Right.
marketing the property for sale, but simultaneously letting you know who's building it.
So, and I like the things in here that talk about it's going to be up no sooner than the date that the building permit was issued, and it has to come down 7 days after the certificate of occupancy. So maybe we just let that happen.
Could a ABC Roofing put a sign attached to the house?
No,
That would be a permanent sign.
but you're not allowed to have a commercial sign, a permanent commercial sign in a residential district. We are carving out exceptions for categories of temporary signs, but we're not carving out exceptions for permanent signs.
And just to reiterate, if you do want to make an exception for that, you need to be able to articulate a substantial governmental interest to make it constitutionally defensible.
You mean to eliminate it?
No, you need to be able to articulate a substantial governmental interest would be the test that a court would apply. And I think that would likely, the argument would be you allow that, but you don't allow a home occupation sign, you don't allow me to advertise my favorite restaurant. Not saying it can't be done, but I just think we need to be able to articulate why we're allowing that, but not others.
I don't have anything. All the ones I wrote down were what the reasons why I didn't want to have it.
Well, I'm thinking in
The
comparison to...
question would be, is the interest, can you extend the interest that a homeowner has to market their personal property to a home builder to market their business to the
Well, he's not a
prospective public?
resident, so he doesn't count, right?
He
It's the
might
residential.
be an
New
owner,
construction,
although
he's
he's
the owner of the
not.
home.
Oh, I
Right.
see, yeah. But it's about residents, it's not about.
Right, but what I'm saying is the seller of the house is actually the builder. So he's the owner, and it kind of coincides with the for sale sign. And they do tend to be aesthetically more put together, at least the ones that I've happened to see. There could be some exceptions to that, but it was just something I figured I'd throw in the mix.
That is true. Well, could you say that in an effort to inform the citizens about construction options,
It's definitely a gray area.
you know?
Well,
I mean, it would be like,
And does that mean every painter, every electrician who comes to work on your house?
But the painter doesn't
Well,
own the house.
but
That's where the
every
distinction.
property owner has a right to say, no, you're not gonna put that up. I mean, even if we say, yeah, leave it in there,
Right.
every property owner has a right to say, take your sign, put it in the back of your truck.
if we're saying to allow these construction signs in whatever case, one of our proposed purposes in the new section is to balance public and private objectives by allowing adequate avenues for both commercial and non-commercial messages. And it seems like that would,
It's a good
I mean, it
word.
seems
I
to fit.
don't have a problem with that.
I'm just trying to think if we could face court action for not allowing commercial messages, construction signs of this
Well, then
kind.
that would extend to commercial advertising of all kinds in residence. And we're allowed to do that. We're allowed to prevent that, so I don't think, that's.
As a
getting-
resident of the
that's
house?
really getting at-
We are allowed to prohibit commercial signs in residential districts. When we start creating exceptions, favored categories, disfavored categories, like we're talking about here,
Yeah.
that is where I can just tell you, a court would look at that and say, okay, they're not allowing pretty much any category except they're allowing this particular one. What is it about that category that, for which there is a legitimate governmental interest, and how does that balance when you put it against the overarching purpose statement,
Well,
which
the
is
Supreme Court said yes to for sale signs, right?
correct?
So that's our, whatever that logic was, we need to know.
And the logic there was the homeowners have a very strong interest in marketing their own home for sale by putting a sign in their yard. There's really no substitute for doing that.
Okay.
So, and the cool thing from that case was cities cannot prohibit for sale signs in your yard. There was a case where a city actually said no for sale signs in our community, and that was struck down.
Yeah.
But so if I'm hearing you correctly and thinking through the logic, if we are generally prohibiting commercial messages in residential areas, this is a point of vulnerability for us. Could be a point of vulnerability.
It is. To successfully defend it, if you carve out an exception for construction signs, but prohibit all other commercial signs, I'm not going to tell you it can't be done. You just need to be able to articulate what is a legitimate governmental interest other than just favoring contractors.
I don't think there is one.
I may be backing down from my
Me too.
perspective then. Yeah.
And it's something that, we put it out there as an option because we tried to anticipate everything you might want to even talk about doing. It's something that, we can research further and report back at the next meeting, or you can think about and talk about more about the next meeting.
So
But
to
it is-
put into words my back-off statement here, in thinking about the possibility that you mentioned, Mr. Martin, of somebody wanting to put any kind of sign advertising anything they want in the residences, that does kind of open the door for essentially doing away with that aesthetic concern for the community. So I think I think the logic is good to not carve out an exception for that.
Okay, just starting at the top of the list, if I could, just to kind of get your pulse of where things stand. On-site real estate signs in residential districts. I think you're wanting to allow that from what I hear, based on the substantial interest of just homeowners should be allowed to sell their home and put a sign in their yard. If I heard you correctly, you want to apply that same rationale to open house signs and garage sale signs on site. Where do you stand on allowing off-site real estate signs, off-site garage sale signs, and off-site open house signs in residential districts? And if you want to allow that, which if you choose to go there, again, you would need to identify your substantial interest in allowing that.
That means on empty lots and
If
off-site, I mean.
Off-site, so putting a for sale sign anywhere other than the property that's for sold, or putting a garage sale sign anywhere other than the property that is hosting the garage sale.
So it's empty lots, rights of way, all kinds of places like that they turn.
Correct.
Yeah.
Well, and, okay, let's say that Dave has a house 4 lots in from the corner, and I own the house right on the corner. And it says that now. David cannot go put a for sale sign on the corner directing people down the street to his place. But if Dave talks to me and I take his sign and stick it in the yard, is it one of the 6 that I'm allowed? And so you all can just go on your merry way because it's my sign today.
That would technically be an off-site commercial real estate sign, and
Okay.
that is
All right.
currently
Just-
prohibited under the code,
Okay,
currently
good.
prohibited.
All right, that's fine, and I'm okay with that. I'm okay with saying no. I don't have a house that sits on a corner, but
Even though my feelings are hurt because we are best buddies, we play pool all the time and things like that. So
hey,
I think, though, if we're going to allow off-site garage sale signs, which we're not going to be able to stop, I think we should be able to allow off-site for sale signs and off-site for rent signs and off-site open house signs.
Wow, that's opening Pandora's box to say.
We have it
we
now.
encourage it.
No,
We do.
we don't enforce it. It's not
No,
allowed.
well.
We have them, but not
it's
legally.
very prevalent, is what I'm saying.
We have them, but not by ordinance. Yeah, they're prevalent.
It'll probably still be prevalent.
Yeah, that's what I'm saying, so let's allow them.
But I think like he's saying, we can't defend it.
You can allow them, you just need to, I think you need to articulate in order for us to get where we want to go with, which is a constitutional ordinance that we know we have to have. We need to articulate something other than the very valid point, which it is hard to enforce. We need to articulate some reason, why do we want to allow that? What is the governmental interest, and how does that outweigh the other reasons that we've cited for prohibiting other types of signs in the first place?
And I think that the potential for violating some aesthetic standard is there. I mean, you can have just a whole clutter of off-site signs if you say they're all okay. I think the fact exists that people will do it, and hopefully they're temporary enough that the kerfuffle is short-lived. But I just see it leading to all kinds of open Pandora's box, I think was what the commissioner said. That's probably right.
If we say it's okay, there will be lots and lots more.
Yeah.
That's what I think. I don't know, do you think? I think it's giving an imprimatur to something that is now psychologically avoided by most.
But I'm thinking, especially like garage sale signs, if we say they can go up a day before the day, and they have to be taken off the day after, because it's going to happen anyway, but at least, I know I've been to many garage sales that were the day before, the sign is still there.
At least you'd have the right to pull it up.
Well, if it's in the right of way, everybody would have the right to
Yeah.
do that.
Well,
Maybe the community or the city's
just because
interest.
something is in violation, if it has value, you don't have a right to touch it.
It's trash. Can't pick up trash?
If I park my car over the curb on the sidewalk in front of your house, you better not move it. There's some other people that you can call to get it moved, but you need to be real careful. We need to not encourage our citizens to go about enforcing the ordinances we have by yanking up signs and throwing them in the street.
You're right.
We're way on the way to a big problem there.
So maybe that's
I
our,
feel that way, but I'm thinking, no.
maybe that's the city's substantial interest,
That's
so
what
that
you
we don't have
call
to do that.
mean. So I think I see a sign.
But if we allow it, we won't have to do it.
Maybe we justify it on the grounds of
Did you-
saving staff, government staff time.
Yeah.
They're calling it a construction project or event.
I have experience by putting an auction sign on the interstate. And the interstate right away runs clear to the fence, folks. And yeah, they pick them up and they don't take them to the closest highway patrol station. They take, this one in particular was all the way in McPherson when I finally tracked it down.
So I'm mindful as chair that time is ticking on, and we've done a pretty good job with this, I think. Is there anything else that the commission wants to state for the record before we move to the next item?
I did think I'm okay with 8 square feet because I think those signs are expensive and people aren't going to, I don't think people are going to put 6, 8 square feet signs. So I'm back to thinking each one being 8 square feet is okay.
That's too bad.
And do we have a general consensus, if I just heard correctly, on the off-site garage sale and off-site open house? Am I correct in hearing that you do not wish to modify the current rules and those would continue to be prohibited?
Yes. Yep. All right, hearing no other statements to the contrary, let's move to item 3.3.
I would not want.
Yes.
Mr. Chairman?
We will need a motion to continue the public hearing on item 3.2 to March 21st to allow us to come back with a public hearing draft for your consideration.
Do I hear a motion to that effect?
So moved.
Been moved?
So we
It's
have a
been moved by-
motion to continue the public hearing on this to March 21st to review a public hearing draft.
It has been so moved and seconded by Commissioner Buffa. Let me handle one thing at a time here. Is there any discussion? If not, all in favor say aye.
Aye.
Opposed, same sign. Motion carries. Yes.
Mr. Chairman,
Mr. Box.
and I'm looking at Dean as I'm saying this, would I be out of order if I were to request a change of order in the agenda?
No?
If the
If-
chair would
if the
entertain a
chair would
motion,
consider that
I would
motion.
like to move that we move administrative item 4.1 next to allow the applicant an opportunity to be heard. There isn't anybody here, I don't think, for the public hearing that I'm displacing.
Is there a second?
Second.
It's been moved and seconded to move administrative item 4.1 to the top of the agenda. All in favor say aye.
Aye.
Opposed, same sign. Motion carries. All right. Mr. Andrew.
Mr. Hers worked on the report for this, but I will just give you an overview, and it is your job to interpret what your motion was, but we want to articulate that neither the applicant nor the staff view what was submitted and is in your packet as a meeting the requirements for a final development plan. So you will have to fill us in on what you were expecting or thinking, but the concept was that we had an unknown use and an unknown layout, and your preference was that this, if possible, be done as a planned commercial district, which requires that the Planning Commission review and approve a site development plan prior to issuance of a building permit. However, we've had many cases where we have a planned commercial district, such as in the vicinity of Schilling in Ohio, where the consideration of the final plan is deferred, and it is understood that the zoning action moves forward subject to a condition of final site plan approval prior to issuance of a building permit. So we just want to start up front rather than spending time analyzing the plan that's before us and its pluses and its deficiencies. We just would note off the top that this is on your agenda because there is a desire on the part of the applicant to stay within a specific time constraint relating to the marketing and sale of this property. And so you recommended approval of Plan C5 zoning for Lot 10 in this case, in lieu of the straight C5 zoning requested, with the review of the site plan and building elevations deferred to the March 7th meeting. We are at the March 7th meeting. We have had a conceptual site plan and conceptual elevations based on another project in another community that's been submitted, and that provides you with information, but we are not in a position, it's up to you whether you want us to go into detail of the plan. So rather than hearing our report, we think you should hear from the applicant about what they submitted, what their intent was in submitting that, and where this is in terms of timing-wise and future submittals that might come to the commission. So with your permission, Mr. Chairman, we would defer making any report at this time so that the applicant can explain the items that were submitted and we have put in your packet rather than us going into great detail on that.
So granted, Mr. Mays. Yeah.
Good evening, Mr. Chairman and Commissioners. If it wasn't for the money, it wouldn't be worth it, would it?
I know,
All
that's
this time
right.
y'all
That's
donated.
Yeah, right.
I had the opportunity to speak with Mr. Andrews at a break and talk with him a little bit about the conversations that I've had with the Popeyes franchisee and what was brought forward and the resistance that we got relative to specific site planning. And the request that I've been asked to bring forward on their behalf is that we consider the zoning question. They're fine with the PC element of it. In fact, with the work that Mr. Ers did was very helpful in that it gave them some very detailed insight into all the things that would be required from a site plan when we brought it back for final review. The pushback that we ran into is economic in the fact that, on a project like this, freestanding building, they're going to spend $60,000, $70,000 in engineering and architectural plans alone. And they weren't willing to go out and spend that kind of dollars, not knowing whether the zoning was going to be granted or not. Their request is that we answer the question of zoning, and yes, then they're more than happy to come back and work with staff or back in front of you to satisfy all of the detailed elements that Dustin brought forward. But what they submitted was illustrative and not, it wasn't site plan specifically to the site for reasons I previously mentioned. So the request that I've been asked to carry forward on behalf of the owner applicant as well as the Popeyes franchisee is that you would consider the idea of advancing the zoning question. The contract, for a little more insight into the deal structure, is such that if the zoning's approved, then they have to go towards closing, which they intend to build there and understand the idea of PC. We've discussed that in detail, and again, Mr. Ers's detailed report gave them the insight into things that would be required in that site plan. None of which, as I talked to their engineer in an airport in Chicago this afternoon, did he say were showstoppers. I mean, the openings, and these were just examples that most closely represented what could and would be done in Salina.
I just some comments because I've thought about this a lot. One of the reasons that we went with the plan was so that we could get a sense for what a business that we didn't know anything about at the time was going to do. And, you can tell them this from my standpoint. I'm a little disappointed that they tried to float such a stinker past us.
What do you mean?
No sidewalks?
Well,
they built this one with no sidewalks?
Again, bear in mind, this isn't site-specific. This is illustrative of what they've done in other communities and been allowed to do in other communities.
Yeah, there, you said the word that just, they were allowed in another community to build a building and start a business without these things in place? Are we so much harder to get along with than every other place? I don't think so. I think they tried to float one by us, and I'm disappointed, big time.
The disclosure piece, frankly, was the applicant was Rose Hill. We're required to, again, contractual deal structure. We're asking for the rezoning of the property on behalf of the current ownership. When we were here in front of you last, I had no idea whether disclosure of the user was allowable or not, so we deferred towards confidentiality. In talking with them and talking about items that you wanted to see, that was. They were fine with disclosing because I told them it was what we were going to have to do to get there. Although I do wonder, relative to the question at hand and the zoning, and it's clear that the commission would like to put PC5 on that piece. Does it matter? Do we think that C5, be it PC5, which is your preference, is appropriate here? That's the question, and then. So we could rezone this to C5 on behalf of the applicant who is the owner of the property. So if, for any reason after the fact, this current franchisee is unable to satisfy your requirements and staff's requirements from a site plan standpoint, the property is still available and it's zone C5, PC5. The next group, we don't have to go through the zoning piece. We still have to go through the site planning piece. So relative to the question at hand, is it your guys' opinion or not that PC5 is appropriate?
I guess as staff, I would point out something that's a little bit unique about this project that we typically don't see, and that's when we come forward with a final site plan review, it's typically because the zoning for that planned development district is already in place. Some recent examples which your body has looked at within the last year, last 18 months or so, the Hilton Garden Inn, that was a planned development district where there's a final site plan that you guys reviewed, and then also the Chick-fil-A. And both of those developments are either brand new or are working towards that direction. And so typically what you find is you have a planned development district that's put in place and it's zoned, and then whenever the development is ready to come forward, then that final site plan with very specific engineered and architectural plans comes forward to you for review. This particular plan gives you a concept of what it is they're looking at, but there's still quite a bit of information that's going to be needed for us to conclude whether or not it's going to meet all the various requirements, and some of them may be things like sidewalks, which are in the report.
And there's just one example.
Sure. No, I understand that.
Again, the plan is not specific to the site. They're not trying to float anything by you. They were trying to conceptually give you a sense of what they build. And they, as I talked to them today, there was nothing listed in the staff's report that they felt that they had any objection to. They're of the benefit of getting staff's report now, even before we go any further, so they know exactly what that site plan is going to require, and they can do all that as part of their due diligence at this stage. But in order to make the investment that is going to be required to be made both in purchase and architectural and engineering, they're wanting a sense of whether we're going to be able to get it rezoned. Because if we can't get it rezoned, they're going to own $60,000, $70,000 worth of A&E that they wad up and throw in the trash. And frankly, I don't know anyone out there that makes that decision.
So I guess the other example or examples is that the Planning Commission saw only a conceptual plan for the development of the northwest corner of Shillington, Ohio, but that is a planned C5 district. And if a use comes forward at the northwest corner of Shillington, Ohio, that final plan will have to come before this body for review and approval. And the other example would be what is called the Auburndale Edition, where Lowe's is. It has a number of outlots there. The plans for those outlots were just conceptual. All you really had was the size and shape of the lot and a concept. And then as plans came forward for Dimeroo and for Rib Crib and for the Holiday Inn and for the Salina Square with the Five Guys restaurant, each of those plans came forward for the Planning Commission's review and approval before the sites were developed. And so from our perspective, since we didn't know whether it was permissible to release, for us, we didn't address our report or anything related to a specific user, and it wasn't our place to do that. So what we have identified as option or alternative 1 on page 12 of the report, which is essentially to recommend approval of the Plan C5, as you essentially did at your last meeting, subject to a condition that a final site plan for the proposed redevelopment site be reviewed and approved by the Planning Commission prior to issuance of a building permit. What that does is it says everyone recognizes that this is conceptual only, and it might be satisfy your curiosity. It would not suffice to be a final redevelopment plan, but what option 1 would do would allow this to move forward so the governing body can consider whether this should be rezoned to planned C5 and whether an ordinance would be drafted to that effect. Then, if that is approved and the zoning is in place, then nothing would happen on this site until a final site development plan that had all of the information that you would expect to have reviewed and reported on would come back. So that is an option. That is not your only option. Your option is say, well, this isn't what we expected, so we want to postpone consideration of this. But by doing that, you are essentially delaying your final recommendation on whether this should be zoned Plan C5 or not, and then it can't go to the city commission until that occurs, but that's probably unlikely to occur as the applicant is reporting that the prospective redeveloper is probably not going to want to commit the resources to do that, not knowing what your feeling is on rezoning the property.
So is there any discussion, further questions, commissioners?
Just to kind of hit a couple points, and I guess for my own benefit, we didn't have any opposition from the adjoining residential area. Is that correct?
It wasn't opposition, it was a comment or concern from the owner directly to the south. They just wanted to make sure that city staff and the planning commission reviewed the proposed site drainage to ensure that this wouldn't create drainage issues for their lot. That was they weren't opposed to the rezoning, they just wanted to make sure that drainage was properly controlled.
And the 15-foot buffer is quite a bit more than the current buffer.
The current structure is 7.5 feet from the property line, so the buffer would actually increase, and it'd be more than that because you'd have a driveway as well. But the existing building sits 7.5 feet from the property line.
I'd vote for alternate one.
Is that a motion then?
Well, are we ready for a motion?
We're ready for a motion.
Okay, and then I would vote that the commission approve the subject property to a Plan C5, following alternative number 1 on page 12.
All right. Is there a second?
Second.
Been moved and seconded. Is there further discussion?
Does everybody understand what that motion entails?
I'm looking at it real careful,
Yeah.
trying to figure that out.
Just to restate that, it
Final
is...
site plan approval, still, is that part of it?
Yeah, it is option number 1 on page 12 of application Z17-2A, which recommends Plan C5 approval, subject to the condition that final site plan be reviewed and approved by the Planning Commission before building permits issued.
So what that means is the decision would go before the governing body. They would decide if they concurred on the zoning question. If they did, that would probably result in the property being purchased, and then the purchaser would have knowledge that they can't move forward with any development plan until it has been reviewed and approved by the Planning Commission.
Any further discussion?
Actually, I thought that meant it went to the city commission. I'm sorry.
Well, the zoning question will go to the city commission with a condition on it that if the property is rezoned, that any development could not occur until you had approved a final site plan. And as Mr. Hers explained, the site where Hilton Garden is where Salina Square is, where Chick-fil-A is. The zoning was established at one point in time and with a condition that no development occur until the Planning Commission had approved the site plan. And so this is taking that approach to this. Rather than having concurrency between the site plan and the zoning, this is allowing for a deferral, and instead of deferring it for one meeting, it defers it until they're ready to submit their plans that meet our submittal requirements.
Would that potentially kill the deal?
No, not at all. Mr. Chairman, that's what we're asking for, is to advance the zoning question, commission ratifies your decision, and then they'll come, then at that point, they flip on their switches and get everybody working to bring the site plan to satisfy your requirements as a planning commission.
Okay, thanks.
So no,
I just wanted clarification on that.
Not at all. That's what we've been after from the get-go.
Okay.
And we just didn't see any point going through and giving you a staff report elaborating the deficiencies that we all recognize. So they acknowledge it, we acknowledge it, you acknowledge it. So it doesn't.
Any further questions from commissioners? If not, all in favor say aye.
Aye.
Opposed, same sign.
Aye.
All right. Motion carries with one dissenting vote.
Thank you for your consideration and changing the agenda.
Thank you.
For all your guys' time.
So, Mr. Andrew,
This
I-
is what our suggestion is on items 3, 3, 3, 4,
yes,
that there be a motion, as we indicated in those reports, to continue the hearing on that to your first April meeting, which will allow us to work with Mr. Martin on that after we've taken care of the sign details. So our recommended action on 3.3 and 3.4 is to postpone consideration of those to your April 4th meeting.
do I hear a motion to that effect?
Yes.
Been so moved. Is there a second?
I second it.
And-
Okay. It's been moved.
Okay, so we had a Jackson and Good.
Yeah. Moved by
Motion.
Commissioner Jackson, seconded by Commissioner Good.
And the
Any
That's for
discussion?
3, 3, 4, to postpone.
Any further discussion?
Slap happy.
If not, all in favor say aye.
Aye.
All opposed, same
Aye.
sign.
Oh, no, my eye was there.
Motion carries. Okay,
that unanimous?
review M17-3.
On 3.5 and 4.2, our recommendation, due to the absence of our chairman, and to give him an opportunity to be involved in that, and given the hour, we would recommend continuation of items 3.5 and 4.2 to your March 21st meeting, and we will just get into those at that meeting and not tonight.
Do I hear a motion to that effect?
I so move.
It's been moved. Is there a second? Is there a second?
Second.
It's been moved by Commissioner Good, seconded by Commissioner Boxa, that those be continued.
So those will be carried, if that's approved, those will be carried over to your March 21 meeting.
Thank you, to March 21. All right. All in favor, say aye.
Aye.
Opposed, same sign. Nay. Motion carries except for one. Are there other?
Yeah, you're like in that position, aren't you?
You gotta have something gotta be renegade on. Are there other matters?
And the other matter we had is we were going to advise everyone that the state of Kansas has declared this as Flood Safety Week in the state of Kansas, despite our drought conditions. But everyone needs to be aware of the safety risks associated with flooding. And we will meet on the 21st, and we'll have the re-advertised correct request area for the Salina Orthopedic Clinic on South Santa Fe. We have a request at the Foxborough, not the one on Foxborough, but the one on 1540 West Schilling Road, which was done as a planned development district, and they would like to have that zone back to straight I-2 from the PDD, and then we will discuss the comprehensive plan and strategic plan. So we had that done as a plan because there was concern about building locations, fences, and gates for farmer access to the north. And the applicant's original request was from I-2, and they would like to revert back to that, from planned development district to just straight I-2 zoning. And we'll articulate that a little more clearly, obviously, at the report. But
Cheers.
you probably had enough for this evening, so.
Therefore, thank you very much, Mr. Andrew.
Yeah,
I
thank
therefore
you.
declare us adjourned.
Thank you, Dustin. Thank